May I please, Your Worship?
Yes.
Lordship, I beg to move one unlisted motion, Your Worship. It's a bail application, Your Worship. And,
Okay.
Since there will be no constitution of single bench before the summer break, I will be allowed to move it today, Your Worship. I have already filed it yesterday, Your Worship.
You have filed it?
Yes, Your Worship.
Anticipatory bail.
No,
Pre-arrest bail.
Bail application.
It's a regular bail.
Yes, regular bail. The motion can be taken out. Much obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 1.
One.
Yeah, so this matter will take a considerable period of time. So this will be allowed to take up after under later stage.
Huh?
After the listed matters, Lordship.
Yes.
In fact, Lordship, if my Lord may kindly consider,
Only one day to
The-
go for holiday. Are you not on holiday mood?
no, Lordship. Every day is a holiday, Lordship. Now, my Lord, the item number 20. My learned friend from Delhi
Yes.
is to appear before his own court. So if this matter, with due permission from my other learned friends, if this matter can be considered to be taken up as the first admission hearing item, Lordship. Item 20,
When? Today?
today, Lordship. It's a short matter and my friend has already reached from Delhi, Lordship. So this matter can be taken up.
Is it first item admission?
Yes, Lordship. If,
No, item 1 is already there in the admission.
yeah, Lordship, and that is also our matter.
So it's a connected matter.
No, no, Lordship, it's not connected matter, but
What is the urgency here?
Lordship, it's a petition under section 482 CRPC for quashing the proceeding before the learned court below, the Chief Judicial Magistrate, Dimapur, Lordship.
Okay.
And considering the fact that my learned friend is coming all the way from
So we'll see.
several occasions,
We'll see. He's here.
is here, Lordship.
We'll see. We have all day. We'll see. What about item 1?
One after finishing all
After vacation,
no, after finishing.
what is the urgency?
Lordship, it has been pending for quite some time now, and then, my clients, some of them have retired in the process. So if the matter is kept pending for long,
So you want that it should be taken after all the matters are finished.
Yes, yes, today.
We'll
Because-
see. Okay,
my lord,
we'll see.
Lordship, my lord.
But there's no guarantee, huh? We'll see.
Lordship.
Mr. Lordship.
Yes.
Lordship, I beg to mention item number 9. Lordship.
9.
Lordship. Here,
You want to file affidavit?
Lordship. After
Objection. Mr. K. Angami,
Digimon,
Jijimo, sorry,
Digimon.
learned counsel for the learned government council pressed for and granted 3 weeks time to file counter affidavit. Miss MS so and so is a present for petition. Yes.
May I please, Lordship, my Lord, I beg to mention item number 6 on behalf of the petitioners.
Hmm.
My Lord, we are filing affidavit in reply in the course of the day.
Sir,
We pray that.
any objection?
No, Lordship.
Sorry, pray
Uh,
that this
Mr. So and so learned counsel for the petitioner prays that he may be allowed sometime to file counter affidavit. Affidavit in reply.
affidavit in reply.
Praise the allowed. List after 3 weeks.
My Lord, my Lord. Much obliged.
May I please, the Lordship.
Yes.
Lordship, I beg to mention item number 2, 6 and 8. Lordship.
2,
On 2, 6,
6 also already mentioned.
2, 6, 8,
2, 6, 8,
7, 8.
7, 8.
8 and 17. On behalf of E.T. Babu.
17.
Lordship,
17 also.
Lordship,
Okay.
on behalf of.
On Mr. So and so. So and so.
Lordship, item 8 I may bring for the petitioner. Lordship, this matter has been fixed on the consensus of all the parties for admission hearing. There is urgency, Lordship. So I have objection for adjournment.
Is it for
Commission hearing,
admission hearing?
item 8. Lordship, my junior has been given promotion. Now he's in the higher post.
Only
Yes, Lordship. No, there is urgency, Lordship. In fact, it's a short matter, seniority only, Lordship.
no, every lawyer says it's a short matter. For me, for this court,
Lordship,
so
matter will be taken up.
if he's not ready, since he's not ready, what to do?
No,
Lordship
counsel, I've already discussed with the council, waiting for this to respond. He's ready, in fact, Lordship. This is point number 1.
We'll see then.
Lordship.
8, rest, that was 2, 6 already mentioned, 2. 2 for what? What file affidavit? Affidavit. Item 2, item 2.
I think, Lordship.
You have mentioned item 2.
Lordship,
Huh,
to come after the vacation, Lordship.
okay. Any objection, sir? No objection. Obviously, yes. Ma'am, do you have any objection? Okay, on the prayer of Mr. Jimobi, Leonard Government Council, list this matter after vacation, summer vacation.
Lordship. I would like to mention item 13, Lordship.
13,
Lordship,
you just give the number,
item 13.
item 13 for government, you are for government, respondent.
For the respondent, Lordship, PP.
What do you want?
Lordship, I'm yet to receive instruction, Lordship. So,
Mr. So-and-so, Jimobi, Leonard Government submits that he is yet to receive the instruction.
Lordship,
Therefore, phrase for sometime list of prayers is allowed, list after 4 weeks.
like,
Mr. So-and-so, you mentioned the name of the petitioner.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 11.
11,
11, my lord.
yes,
Your lordship, I am yet to receive instruction in this case. If 4 weeks' time can kindly be granted to me, my lord.
Mr. So-and-so, Learned Government Council,
Lordship,
praise for and granted 4 weeks times to file control affidavit.
okay.
Mr. So-and-so, for petitioner, present.
deeply obliged.
May I please, your lordship?
Yes,
I beg to mention item number 21.
21.
My senior Easy Mommy. Your lordship, he is currently out of station, so kindly list the matter on July 18th.
You are for
Respondent 2 and 3.
2 and 3. Objection, no. MS So-and-so, Learned Council, appearing on behalf of Mr.
Easy Mommy.
Jimobi, Learned Council for the appellant. Press for and granted 4 weeks time. List this matter after 4 weeks. MS Vishokri, your PP, learned additional PP. And also
Lordship, I am for the respondent number 1, lordship.
Mr. So-and-so present.
I'm for the respondent number 6.
Mr. So-and-so, just give those name present.
Much obliged.
Please, lordship.
Yes,
Lordship, I beg to mention item number 5, lordship.
5.
Lordship, I pray that this matter may come up after vacation, lordship.
On the prayer of you are for
The petitioner, lordship, Mr. P.P. Paul.
Mr. So-and-so, Learned Council, appearing on behalf of Mr. P.B. Fall.
Lordship.
Press for listing the matter after summer vacation. Prayer is allowed, list after summer vacation.
Obliged, my lord.
Yeah, this your lordship.
Yes,
Lordship, I would like to mention item number 15.
15.
Your lordship, we have to file IA. Kindly grant us 2 weeks time.
IA. You are for
Petitioner.
listener. IA, you want to file IA. Anyway, there is no bar in filing, no objection. Ms. So-and-so, Learned Council for the petitioner submits that she would like to she would like to file interlocutory application in the matter. Therefore, press for sometime list of Prayer is allowed. List after 4 weeks.
Please, Your Lordship.
Yes,
I beg to mention item number 10
10.
on behalf of Sir Mo Imchen.
Okay,
The state is yet to receive instructions, so Lordship, we can list this matter on 18 July.
I have no objection, Your Lord.
no
Am I
objection.
praying for the petitioner?
MS so and so learned government council. Praise for 4 weeks time.
Lordship, we can list this matter on 18 July.
Will not fix it if you have not received the instruction. What is that? Praise for 4 weeks time to file contrary affidavit. List of prayer not being objected to by the learned counsel for the petition. Prayer is allowed. List after 4 weeks. You have not received the instruction,
Lordship,
so unnecessary will not.
okay.
May I please, Lordship?
Yes,
Lordship, I beg to mention item number 3 and 4, Lordship.
3 and 4.
Correspondent number 4 and 5.
Okay,
Lordship, kindly list this matter after vacation.
objection no.
No objection.
Mr. So and so learned counsel for respondent
4 and 5, Lordship.
4 and 5. Press for listing the matter after 4 weeks.
Yes, Lordship.
List of prayer not being opposed by the learned counsel to the petitioner. List this matter after 4 weeks.
Obliged.
Much obliged.
Yes, if the 8.
Sometimes.
Yeah. Okay, okay, okay.
Lordship,
What is the matter?
Lordship, there's a dispute with regard to industry seniority between the petitioner and the respondent number 7.
Okay,
Lordship, in short, Lordship, the case of the petitioner is that petitioner was appointed in the year 2000 as Jamadar.
just. Take this out. You did yesterday that matter of CAB. Put it there. Whatever I can know. Yes. Appointed?
As Jamadar under village court organization, under village court organization.
Okay.
Respondent number 7,
Jamendar appointed on
appointed on 25/7/2000.
25/7/2000.
Yes.
Okay. Respondent?
Respondent number 7 was appointed in the same post.
Same day.
No, Lordship, in the year 2001.
Which date?
14/5/2001. Now the dispute is in the seniority and the cadre of Subedar Major.
Subedar Major.
Lordship, by
It's a high, the next promotional post.
next is Subedar
Subedar.
and the present dispute is Subedar Major.
Okay. You are in. You have already crossed Subedar.
Yes.
Subedar no dispute.
Notice.
Okay.
So by command order dated 24/10/2016. 2015. The petitioner and the responder servant were promoted to the post of Subedar
Subedar
Major.
Major on
24/10
24/10
is
2016.
2016. Yes.
Okay. Same date, same order,
Same-
by same order.
same order.
What is the principle?
Lordship, there is no service role. There is no service role governing the.
The
service-
general principle.
Yes, general principle. Is-
What was the seniority position in the post of Subedar?
Lordship, a tentative seniority list was issued after the promotion. The petitioner being the senior in the lower grades. That is the entry point. He was shown.
He was appointed earlier than the respondent number
Yes.
7.
So.
That is your
consider the level
claim of
service.
basis. The
Consider-
basis of claim is that
Yes.
since you are in the entry level, you are appointed earlier than the respondent number 7.
Yes.
In the next higher promotional post, you should be senior to him.
Yes. According to Lordship, seniority list was published
Okay,
in the year 2018 of the promotion,
yes.
in which the name of the petitioner is shown senior to the primary respondent.
That is your,
That is seniority, tentative seniority list. Dear late Lordship, no final seniority list has been issued in the rank of Subedar Major. Now, what happened, Lordship? After the tentative seniority list was issued, the respondent authorities again issued another tentative seniority list, in which the name of the primary respondent has been shown senior to me, on the ground that the primary respondent submitted training report to the promoted post earlier to the great petition.
In the entry level or in the promotional post?
In the promoted post.
Major Subedar,
Subedar Major.
Subedar Major.
So date of joining in the promoted post has been considered by the respondent authorities for determination of this industry seniority between the petitioner and the primary respondent. That's immune tentative seniority list, that is not final seniority list, Lordship.
Have you filed the objection?
No, Lordship. That subsequent.
Let us the impugn seniority list. If you have not filed, you approach, you file, they'll rectify it.
Lordship, no, Lordship. There are two tentative seniority lists, Lordship.
First also you are junior.
I'm-
First
I'm
tentative-
senior, Lordship.
First
Lordship, I need to do page
tentative
31, page
Ah.
31.
31. Yes,
This is the memorandum dated 14/9/2015. As decided in the last division meeting held on 19 July 2015, when it was decided to have a common seniority list of Subedar Major of all districts. Therefore, the tentative seniority list of all the Subedar Major under the list of the list prepared as where the records, as where the service records, false.
is prepared.
Any objection, correction, clarifications may be submitted when there is from the issue of this memorandum. Which is received within this stability that seniority list was on 1/9/2025. Page 33.
Your name
My name
7.
is Ed Cyril Buston.
and respondent number 7, 8.
So number 8.
8,
On
okay.
the second column, Lordship, take up training into government service. Third column. 27/7/2000. That is the petitioner.
Hmm?
Third column,
Yes,
take up training into government service.
yes.
And in respect of respondent number 7, 14/5/2001.
Yes. You said 24
14/5.
and then you said the petitioner was appointed on,
27/7/2000.
you said 25.
Insurance.
So date of joining and date of appointment is different?
In the entry level?
Yes.
No, Lordship.
Then
And next column, Lordship, column 4.
that means 14.5. Respondent number 7 is 14.5,
Yes.
Not
What is the date of entry?
not 24. Not 24.5, 10. Yes.
And next column, column 5, Lordship.
Hmm.
That is the date of last promotion, that is promotion to the boss of Subira Major.
Date of promotion. Same date.
24/10/2016, 24/10/2016.
Same date.
Lordship, may kindly turn to the promotion order.
Just wait.
Promotion order is at page 29.
29.
That is
Yes.
dated 24/10/2016.
Hmm.
And pursuant of the recommendation of the Department of Promotion Committee, promotion was made under recommendation of the DBC Lordship. Let us say so, and the government approval letter so, let us say so, the following Subidar are hereby temporarily promoted to the post of Subidar Major. And the pay ban of so, all other relations are admissible. Such category of abuse under rules force for BG of national from the date of joining the post. So accordingly, Lordship, the seniority list was prepared.
So this serial number 1 is respondent number 8,
Student number 8, 7, Lordship.
7. I'm sorry.
Serial number 2 is the petition.
Petitioner.
This is the promotion.
So what is this rules? Rules says the promotional rules, the recruitment rules.
There is no role, Lordship.
How it is promoted then?
For DPC, Lordship.
DPC, for DPC also there must be something. Is
No,
there
sir,
office memorandum?
By filing the affidavit of opposition by the respondents, if enclosed a draft service law. So the draft service law provides for consideration of promotion by DBC.
Okay, they have relied on the draft service law.
I'll come to that.
It
Lordship.
it is
DBC.
permissible
Yes, Lordship.
if there is no
Yes,
rule.
permissible, Lordship.
So what does it, what does it,
They
what does it say? What does it say? What is the method?
Lordship, rule 7 clause, rule 7 of the service law provides for promotion of the employees through DPC.
That's all.
And the criteria for consideration of the promotion is first, final seniority list, service records, APR, ACRs.
Hmm.
So promotion, so far as the promotion is concerned, Lordship, it was done in accordance with law.
Only issue is inter-seniority.
Industry seniority.
So what is the basis of your claim? No, before that,
Yes.
the page, this first tentative list, page 31 and 32,
Yes.
it's in your favor. You are senior too.
Yes, that is in accordance with Lordship.
Then what is the impugn,
Lordship, what happened, Lordship, before I come to the impugn orders. After this tentative seniority list, Lordship,
yes,
no final seniority list, I never came across any objection filed by any person.
okay.
However, Lordship, in the year 2022,
As it says, if no such objection is received within the stipulate that seniority list as on so and so will be final.
yes,
Are you relying this?
yes,
Anyway, I've seen it.
yes.
What
So,
happened
no
there?
final seniority list, Lordship, as of now. So what happened in the year 2022?
Though there is no objection as such, no final seniority list was published.
However,
correct.
in the year 2022,
Yes,
what happened, Lordship? The previous respondent, number 7, was promoted to the post of assistant commander.
assistant commander.
Based on the seniority list, which was never circulated, which was kept and disclosed in the department, which seniority list was the basis of the recommendation of the teams in favor of respondent number 7. The seniority list was available to the petitioner only after getting information through the RDI
That after the promotion
after the promotion.
to the assistant commander.
Yes, Lordship.
Okay.
So Lordship, may kindly to the impugn order, first impugn order, Lordship.
Page
Page 34,
Yes.
page 35,
No, page 34 is the promotion order of respondent number 7.
page 35 is
Page
the
35.
type of the lordship.
Okay, then
Mayor, read lordship.
then come to your impugn seniority list.
And to your lordship, I filed in RTI,
Yes.
page 39,
29,
39 lordship.
39. Yes.
Lordship, we kindly turn to page
40.
40.
Yes.
This document was
Consider
made
case of
available through
limit
the
provision.
I'm meeting up the DBC to consider the case for case of regular promotion of officers of the Home Department, DGU, was held on 15/7/2021 in the conference hall, Nakadu Public Service Commission. The following members were present. The finding lordship, the Departmental Promotion Committee. after
Yes,
doing-
yes, I've seen it. Come to page 41.
So lordship, that was the recommendation of the Departmental Promotion Committee. The first consideration was the seniority, lordship. Second consideration was the service reports of our and the ACR. And rather subsequently, lordship, this view seniority list was discovered. Page 41. This is not a final seniority list, lordship. Tentative seniority list of all the Subedar Major under DG organization was on 15/9/2018. Next page, lordship. The seniority position has been reversed by this new seniority list. Serial number 7, lordship. Is the respondent number 7? Fourth column, lordship, date of last promotion and date of joining. Serial number 7.
25 and 26.
Date of promotion is 24/10/2016. Now the seniority list has been prepared
Yes.
based on the date of submission of the joining. They have chosen and arbitrated because lordship, date of submission of joining report should not be a
Yes.
criteria for determination of
Yes.
seniority.
What is the basis?
That is the basis, lord.
Computing this kind of fixing the interstate seniority. What is the law?
My lord,
What is your basis?
in the instant case, basing on the seniority list, basing on the joining report, since common order was issued, that common promotion order was issued on the same
24/10.
date.
Yes,
So since the promotion order was on the same date,
yes.
so the date of joining was different. So the person who joined the first has
Is it-
given the first.
Is it the law? Is it the law?
Yes, there is a law, my lord.
Is it the law?
Yes, my lord.
Yes. Show me.
My lord. Kindly allow me to rely on one judgment, my lord,
Okay.
Supreme Court judgment.
Before that, anyway.
Yes.
So you have relied on the Supreme Court judgment
Yes,
by in fixing the seniority
yes,
on the basis of date of joining
yes, my lord.
in the feeder grade.
Yes, my lord. Because this is the seniority list of Subedar Major.
Hmm.
So that Subedar Major list, the seniority list of
But
Subedar Major.
what about the first list, tentative list, where no objection was filed? And if
Earlier,
no-
yes, my lord, earlier there was one tentative seniority list.
yes,
In that tentative seniority list, private respondent was below the petitioner.
yes.
So that is why the private
So
respondent.
according to him, there was no objection since this memorandum of 14 September 2018
Yes,
says that if no objection is received,
yes,
it will become final.
yes. So the private
So the-
respondent has objected.
Where it is? You have,
But
you filed the
private
affidavit
respondent has submitted representation, objecting that,
within the stipulated period,
yes, my lord,
within 30 days?
yes,
Okay.
Lordship,
Then this impugned seniority list
was rectified.
is also again a tentative list. Tentative seniority list.
Yes, yes.
Why you have not finalized? Suppose in this case, not suppose, in this case, there was a right to object to the tentative seniority list. You have objected. And on his, on the private respondent 7 has objected.
Yes,
On his objection, you have changed it.
yes, my lord.
In that case, don't you need to give an opportunity to the petitioner who were placed above him? Because that was also tentative. He should have been given a right to protest or object. If you have decided to have this, because it's a tentative again. You just cannot, on one, you have to treat them equally. Equality.
My lord, since in the first seniority list, there's clearly mentioned that those who have objection. to
No,
file-
he cannot have an
So-
objection. But they agree, the private respondent 7 has the right to object. Accordingly, you have prepared this impugned tentative list on the objection of the respondent 7.
Yes, yes.
He has rightly done so. But while preparing it, don't you need to give an opportunity to the respondent 7 who have been pushed below the respondent 7, where he was earlier on top of above the respondent 7? Since you have not finalized it before finalization. So before finalization, can you again deprive other employee? Wrongly or rightly? That is number one. Number two, the basis of, we'll come to that, you're considering the date of joining. If it is permissible, it's okay. If it's not permissible, we'll see to it. So what do you say?
Lordship, district
What is
government
the law in such a situation? Do you have anything?
unsatisfied Lordship, but before that Lordship, district government,
So it's in admission stage, we'll admit this, I prima facie, it just need to be determined.
otherwise parties are ready for hearing.
Huh?
Parties are ready for hearing.
No, it's in admission stage. Well, that's why
Take it up as
I,
a question.
I promise, prima facie findings to be admitted. We'll admit this, we'll fix it after the summer vacation. I'm not saying that you are not ready. You may be ready.
In fact, this was, is.
So is there any interim order?
No.
So we'll dispose of, we'll hear it in after summer vacation. Heard Mr. So-and-so, learned counsel for the petitioner, and also heard
E.T. Pakpon,
for
State Council,
state
State Respondent.
learned government advocate, Mr. Tompok Pongener, for respondent number 7. Do you have anything to say? We'll admit this petition. Okay. The matters relates to inter-se seniority of the petitioner and respondent number 7 in the grade of Subedar Major. Please stop. The case of the petitioner is that since he has entered the service in the entry grade earlier than the respondent number 7, he ought to have been given the seniority in the next promotional post also. Please stop. In the tentative seniority list published by the respondent, page dated 14/9/2018. The petitioner was the petitioner's name appears at serial number 7 above the respondent number 7. While publishing the tentative seniority list, publishing the seniority list, tentative seniority list, 30 days time was given to file objection, if any. List of petitioner submits that there was no objection as such from the respondent number 7. List of. Surprisingly, not surprisingly, after thereafter, another tentative seniority list was published, whereby the respondent number 7 has been placed above the petitioner, basing on the date of joining in the post of Subedar, as they were appointed, promoted on the same day. These facts came to the knowledge of the petitioner only when the respondent number 7 was promoted to the next higher promotional post of Subedar Major through RTI. Next para. I have heard the learned counsel of the parties. The issue involved is the determination of entity seniority between the respondent petitioner and the respondent, which needs elaborate deliberation. In view of that, writ petition is admitted for hearing. List this matter after 4 weeks. 3 weeks for hearing. For hearing. 15. 18 we have picked so many matters. Let us see. It will be listed in the hearing. Usual course.
After 2 weeks,
3 weeks. Because we have already fixed so many matters in the opening first week of opening of the court. After 3 weeks.
Lordship, I have a small prayer. In my affidavit which I have filed,
Yes.
with regard to tentative seniority list, the actual list is missing. I have, it may be missing in the main affidavit which I filed. Allow me to.
You file a fresh.
Lordship, yes.
You want to
I would like to just
insert that.
insert
Mr.
pages.
Tampo Pongendo submits that while filing his affidavit, additional affidavit in opposition, inadvertently the final seniority list. Final.
Yes.
Final.
No, that is the.
Seniority list. We'll say seniority list has not been inserted. Inadvertently, the seniority list has not been inserted. Therefore, he pressed for allow him to insert the seniority list in his affidavit. It is affidavit in opposition. Praise allowed.
What's it?
Your Honor, I am Tejangde in the
Sir.
case of Tejangde versus CIJSR. I'm petitioner number 1. And today I would like to request you to allow us to represent our case. Because these keys have been going for a long time and
You
we
are-
exactly doesn't know we don't know what is going on with our case. And our counsels, last counsel that the court appointed for us, his time was not there for us. And what submission that one submission that he made, without the knowledge of us, he submitted, or without the knowledge of us, he agreed with it with the ends letter. And we are not happy with that one. And that's why we told him, if you're not available, if you cannot make your time for us, then please dismiss yourself. So that's why we are here today.
You want to argue the matter?
Yes.
In person.
Your Honor, yes.
What is the matter?
It's about.
But it's in fact, it was listed on 19 June. Nobody appears, so this was listed for today. And there's another procedure, you may not know also, that it's in the order column, whether service reports on the respondents
Okay.
has been received back or not. That procedure is there, process is there.
Okay.
So as per the office note, it says the service reports on respondent number 3 and 6 is still awaited. So we'll wait for some time.
Okay.
Because there are, I mean, stages. Motion stage, admission stage, order stage. Order stage, we see whether the process has been completed or not. So we have to hear the other parties also. So we'll list this matter after some time, because the service notice
Okay.
on the respondent number 3 is yet to be returned.
Okay.
After the return, if they don't appear, only then we can proceed.
Okay.
So today we'll, in view of this non-return of the service,
Okay.
we'll fix the matter after 4 weeks. What is the matter? What is the matter?
Actually, it's about a medical negligence.
Okay.
If I may speak, initially we filed for medical negligence, but our counsel at the time told us that the judge refused to let the case go ahead for medical negligence due to it being filed in the wrong forum. But when lately we've been getting all of the files, actually till date, none of the advocates have provided us with all of the files, like the interim applications that were submitted. We've never seen those. We had no clue about them. Only very recently, within the last few days, we came to see some of the things that were filed in the court on our behalf. And we're very confused about it because from the orders that were passed, it doesn't seem that the court denied the case to go forward as medical negligence. It seems that our previous counsel is the one that retracted it. And for what reason that is, we really don't know. So we would like to get a copy of all of the files so that we can go over everything and get a clear idea of what's been happening in the case.
In that case, you have to contact your previous counsel whom you have engaged, and you will get the file from him.
The problem is the council is not communicating with us at all for many months. We've tried to get the documents from him, but
Where he is from?
he's the amicus curiae Moa Jamir.
Okay.
He's actually in court 1 right now.
Okay.
We've tried many times. He doesn't.
If
answer.
he is there, he'll certainly provide you the briefs, the files, and
We've requested him multiple times.
Or-
for months and months.
okay. In that case, also you can apply it for the copy of this.
Yeah.
There's a procedure. You go to the registry and you apply the copy of the writ petition and other related documents, whatever you like.
Okay,
There must be
Your Honor.
some advocate's color, will guide you.
Okay, thank you, Your Honor.
Thank you.
So we'll fix this matter after 4 weeks in view of this office note. Office note dated. Please, why should it?
That is one.
Well, that is one. You don't have to do it.
This was the first one. Such.
Same thing. So after this, how many years together?
After this, already 1, 2, 3, 4 times. The latest.
Under the service of this
is on this.
first
You might have
service.
to- You might have to take first on this.
I mean, the petitioners, the steps were taken on 28/7/2022, 1 year back.
Yes.
I think until today, no service report. So in that case, you'll have to take press steps for respondent numbers 3 and 7. 3 and 6. So in that case, we'll just fix it after 4 weeks or 3 weeks, whenever you like. But then you get the records and take steps. All right.
Yes, Your Honor.
Should I pass the order for taking steps, or you'll would like to obtain the records first?
Yeah, we would like to obtain the records
Okay.
first, sir.
Heard the petitioner in person. Office note dated 28/6/2023 indicates that service reports upon respondent number 3 and 6 is still awaited. Please tell. It transpires that the steps were taken on 28/7/2022, a year back. Please tell. Please tell. The petitioner in question submits that they would like to obtain the copy of the writ petition and other connected documents from this registry, for which they need some time. List of and press for some time to obtain the same list. Press is allowed. List this matter after 4 weeks, so as to enable the petitioner in question to obtain the copy of the writ petition along with other connected documents from the registry. Right. List is after. Then we'll pass when you next list will direct you to for steps.
No, please, Lordship.
Okay.
Lordship, the PP is engaged in the court number 1. Your Lordship.
So what to do? Will issue notice?
Okay, Your Lordship.
It's a regular bail.
Yes, Your Lordship.
Hard Mr.
Zatpur.
So and so learned counsel for the applicant.
Yes, petition.
Who is the petitioner here?
He's the father of the accused.
Okay. Applicant. List of. This is an application under section 439 of CRPC, 1970. Praying for grant of bail to the accused person. Sri Nurul Muhammad.
Yes, sir.
Alias Nur Muhammad. In connection with the
GR number 390.
Newland PS case number 0014 of 2022 under section 307, 326
506.
and 307, 326, 560 of IPC. Corresponding to GR case number 398 of 2022. Issue notice. Call for the city.
Yes.
Call for the city. List is list after 2 weeks.
When the CD is received, Your Lordship, or after 2 weeks.
Then we'll say call for the CD. List the matter as and when CD is received.
Yes, sir. Much obliged.
I don't know what.
Right.
For admission, item number 1.
Okay.
Mr. Lordship,
Yes.
my sincere apologies, Lordship. My senior was here. He was supposed to take up the meeting. Maybe he's out for some.
He's in the canteen.
No, Lordship, he's somewhere around. Please allow some few minutes, Lordship.
Up to some time.
My lord, I'm looking for MD some additional AG. He's in court number 1.
Thank you.
He'll come
After
after
some,
some time.
Item number 14.
Tongpok Pongrenor. None appears on call. Listed matter after 5 weeks, 4 weeks.
Item number 16.
May I please, your lordship?
Yes.
I'm mentioning on behalf of Lucy, senior government counsel for the state respondent.
Hmm.
She's pleading is complete, so let the matter be taken up after 2 weeks, madam.
No, this is in the hearing list.
Lordship, my senior is in courtroom 1 with me.
So when do you want? After 4 weeks?
After 2 weeks, madam.
What is the matter?
She's in disposed, madam.
What's the matter? What is the matter? What is the matter about? This matter?
Item number 16.
16. Item 16.
Lordship,
What is the matter?
it's about appointment, Lordship.
Okay.
An ad hoc replaced by another ad hoc, Lordship.
What is the law? 1998.
Yes, Lordship. General principle, Lordship.
So
that
he's
applies.
not general principle. It is settled proposition.
Settled.
So my
When,
lord,
when?
after 2 weeks, madam.
Mr. So-and-so, learned counsel for the learned government counsel appearing on behalf of
Lucy.
MS Lucy. Yes. Then the senior government advocate
Yes, madam.
submits that she is reportedly, she and submits that she is indisposed.
Yes, sir.
Accordingly, praise for 2 weeks. Is the praise allowed? This after 2 weeks.
Much obliged.
Item number 18.
Also, in this matter, Lordship, the learned government counsel, Lordship, is on his legs in the other court, Lordship. If this matter may be taken up after all the listed items, Lordship.
We'll see after some time.
Item number 19.
Item 16 is mentioned. Item 16 mentioned. 2 weeks. 2 weeks. 19, Jed Zimomi.
Please, Lordship. Lordship, the petitioner, Madam Zejumomi and my senior, Mr. Fosako Fote, they are both on their legs in court number 1 at the moment.
So after 4 weeks, on the prayer of the learned counsel to the petitioner, list this matter after
Lordship,
4 weeks.
this matter be taken up after the
No,
break.
almost.
May I please, the lordship,
Yes,
since my senior counsel is engaged in other court, let the matter be passed over. for the later part of.
All pass over.
near
What
to
what do you want?
Lordship,
Are you-
we are ready for the matter to be heard, Lordship. With only-
What is the matter?
Lordship,
Is there any urgency?
Yes, yes. We are taking now.
It's
Lordship is for the petitioner to either press or not to press today, Lordship, since the council is in.
what is the urgency? Urgency is there. Because we have passed over so many matters. After vacation,
Lordship,
we'll see if he doesn't come in. We'll see after some time. Pass over.
Lordship.
Yes.
Look, this matter is listed for hearing today, Lord. I have, the petition is at least the order of summoning which has been passed by the magistrate. Lord, what I've done is, Lord, I've prepared a small compilation with my written submission because there was a direction of the last.
How long this will take, Mr.
Lord,
Council?
I'll take not more than 45-50 minutes. I have the judgments ready. I've prepared the written submissions. I can hand over. I'll just have to take your lordship.
No, it's not that.
Look, but it is a case where.
It's a very, I mean, it's good for the lawyers. Make submission, hand it over everything and go back.
No, I'll argue the matter. I've come from Delhi all the way just to argue this matter. Last time also the matter could not reach. That's the reason Mullah was listed for hearing today.
So it's a beautiful place,
I know, Mullah.
pleasant weather. You come back next time.
Mullah,
Enjoy the beauty of Northeast, especially the Kohima.
But I've prepared everything for your lordship's consideration, Mullah. I'll assist your lordships. I'll not take more than 45.
No, you are bound to assist me.
Mullah, I am.
It's not the question of you submitting that you will assist me.
Mullah, I've taken very crisp grounds for.
Are you ready?
Lordship, I am ready, your lordship, and as per the last order, we were permitted to file a written submission, submit written submission. The written submission is ready.
Okay.
As I'm concerned, your lordship, and I will be just referring to the written submission. I will take it back maximum half an hour, your lordship. I will just to save time, I'll be just referring to the written submission, which I've already prepared for your lordship.
Okay.
Mullah, great. First of all, Mullah, can I request my lords, if I could request my lords to come to the complaint, which is the basis on which the summoning order has been passed. And my lords, all the judgments, with all humility at my command, all the judgments that I'm relying upon only talk about as to what is the complaint and what is the evidence which has been used along with the complaint. So what happens in this case is, if your lordship will straight away come to page 42, my lords, which is the complaint. And my lords, the allegations against me are under 406 and 420. And if your lordship will come to the complaint, your lordship will come to page 42 and extra C. Your lordship will see the accused or the persons who have been named as accused are two. One is the company. 42 minutes, and extra C.
Yes.
Your lordship will see it is UM Green Lighting Private Limited, having its registered office at 806 Devika Tower. And the second is Gaurav Mamik. He is a resident and he was one of the directors. And if your lordship will now turn the page and come to the contents of the complaint.
Page
43 minutes.
Okay.
Your lords have it. That the complainant before this honorable court is Shri Santosh Kumar, consultant of Messrs CSA Corporation Private Limited, formerly known as Orsus Agro Developers Private Limited, residing at Dimapur, Nagaland, within the jurisdiction of this honorable court and duly authorized and empowered to file the complaint. Messrs CSA Corporation is a company incorporated under the Indian Companies Act. Your lordship will skip that. Your lordship may come to the next para. That the accused number one is also a company incorporated under the Indian Companies Act, having its registered office at 806 Devika Tower, Nehru Place, New Delhi. And the accused number 2 is the managing director of Mrs. UM Green Lighting Private Limited. That Energy Efficiency Services had issued an invitation for bids with a dated 15 September 16 for the design, manufacture, supply, erection, testing, and commissioning of standalone LED street lights in some states, including complete system warranty and its AMC for 5 years under Atal Jyoti Yojana, Ministry of New and Renewable Energy, Government of India. That in response to the above said tender, the accused number 2 approached the complainant and offered to execute the work jointly and submitted bids, and also successful in the bids there, whereto the accused number 1 company, represented by accused number 2, entered into an agreement dated 1st of May 2017 at Dimapur, Nagaland, that the above said consortium stroke joint venture agreement executed between the complainant and the accused was also authenticated and registered on 12th of May 2017. A copy of the consortium stroke joint venture agreement is annexed as Annexure 1, that in the above said consortium joint venture agreement dated 1st of May 17, it has been, besides the other condition, also stipulated that the allotted works of design, manufacture, supply, erection, testing of 10,000 numbers of standalone grid solar LED street lighting, including complete system warranty and its AMC for 5 years under AJAY in one of the in any of the states of Assam, Bihar, Jharkhand, Odisha, and Uttar Pradesh shall be undertaken by the complainant and the accused jointly. That the complainant begs to state that the accused number 2, on all the occasions of the payment against the works released by the department, has collected the shares of the accused number 1. That the accused number 2 has further took the responsibility for procurement of light, installed the same, and for the maintenance of the light during the warranty period, and collected extra amounts in that regard for the aforestated works. The accused number 2 appointed his own persons to do the work. That the accused number 2, in that context, keeping the complainant on dark, even did not complete the supply of light, also in some phase did not complete the design, manufacturing, supply, erection, testing in time, and it is for such action of the accused number 2, the complainant company have been served with show cause notices by the department EESL. That the accused number 2, having hatched the plan to deceive the complainant, induced the complainant at Dimapur and entered into consortium joint venture agreement dated 1st May 17 at Dimapur in respect of the above said electrification works and for submission on behalf of accused number 1. But after obtaining the work and taking the responsibility of maintenance of the work as expert, and after collecting share intentionally, ignored the work of maintenance pertaining to the electric light commissioned in Uttar Pradesh, Bihar, and other states. That the accused number 2 has also collected huge amounts from the complainant for the sake of maintenance of the commissioned electric light, which the complainant paid, even borrowing from other sources to keep intact the goodwill with the complainant company. But the accused number 2, collecting such huge amounts in the name of maintenance of the light, has not employed proper adequate employees and abandoned the maintenance work, collecting money from complainant inter alia for employees' salaries. That the complainant has information that the accused number 2 is planning to leave India to abroad for settlement to avoid responsibility of maintenance work. That the accused number 2 has committed offense of criminal breach of trust, cheating, making wrongful gain, and as such, the accused should be booked in appropriate provisions of law and put the accused number 2 to trial. Then, your lordship, my passport number is given, and then 16 is that I'm staying outside the jurisdiction of the court. Along with this, if your lordships will turn to page 49, Annexure E. There are 3 witnesses who are named in the complainant, 2 witnesses, stand corrected. 3, sorry. One is the complainant himself, the second is Krishna Das, and the third is Rishitam Jain. Then your lordships will turn to page 51. 51, where the first evidence is recorded by the magistrate.
Yes.
My lords, if I could beseech my lords to come to page 51, my lords.
Yes.
This is statement of Santosh Kumar Jasrasiya, who is the complainant before my lords. My name is Santosh Kumar Jasrasiya. I am the complainant in this instant complaint. I am presently serving as a consultant in CSA Corporation, which is located at village Dimapur, Nagaland. I have been serving under the corporation for more than 6 years. I have filed the complaint petition against Green Lighting and Shri Gaurav Mamik, who is director in the above mentioned company. My company where I work as a consultant deals with solar lighting business. The head office is here in Dimapur. The accused persons also deal with solar lighting business. In the year 2017, in the month of May, we had entered into an agreement with Green Lighting Limited. In the said agreement, it has been agreed between the parties that Green Lighting Limited shall provide 5 years maintenance service in connection with solar lighting installments made by our company in 7 states. In view of the agreement entered into between my company and Green Lighting Private Limited, a bank guarantee has also been submitted to the department, that is the Energy Efficiency Services Limited, Government of India. 2 bank guarantees totaling to an amount of 1,06,61,000 has also been deposited in the month of September to the department. Because this is important, the accused company, after entering into the agreement, had provided his maintenance service for 1 year and had also during his time period taken an amount of rupees 60 lakhs from time to time from the complainant. Thereafter, the accused has failed to provide his services as agreed upon on the pretext of one or the other reasons. This is the allegation against me, that I have breached the contract. That is the only allegation against me. Then, my lords, the witness further says, in this connection, we have communicated with the accused company. However, accused number 2 informed us that he intends to leave for the US and will be completing the contract work only after his return from the US. The complainant company has also been receiving termination letters from EESL to the effect that the work has not been executed. Hence, this criminal complaint petition before this honorable court for this court's intervention, as the bank guarantee amount deposited by our company shall be forfeited, our company will be blacklisted. So the Malords, the allegation is that there is an agreement which is entered into. In terms of that agreement, I was supposed to do works. I have not done those works, and therefore there is a complaint filed against me. Instead of approaching the civil court, seeking a specific performance, and I would show from the documents from the agreement which has been entered into, every single penny was supposed to go to the respondent or the complainant, because it is so recorded in the agreement that an account will be opened by the respondent number 1, who's the complainant, and every single penny from the execution of the work will come to their account. So where is the question of me going and getting the money from anywhere? And if your lordship, the complaint does not spell out a single document. Every allegation is vague. It has been done only with the intent to somehow the other bring my case or the allegations under 406 or 420. Now further, my lords, very important, next page, the witness further says, I am also to state that the accused company has failed to comply with the agreement, which is going to cause heavy loss and damages to our company.
Pure breach of contract.
Pure breach of contract. Now further, my lords, if your lordships will come to the testimony of the second witness, which your lordships will find on page 53, my lords.
Yes.
My name is Rishitan Jain. I know I am here today. I am acquainted with the facts of the case. I am presently serving as office assistant in the company of the complainant, Messrs. CSA Corporation. I have been serving in this company for the last 4 years. Our company deals with solar lights, maintenance and installation. So he says, my company deals with solar lights and installation. So, my lords, both the parties are dealing with installation of solar lights. Further, my lords, the witness says, in the year 2017, accused number 2, Gaurav Mamik, came to our office in Dimapur and we got introduced to him and his company. The accused company also deals with solar lights maintenance and installation, and they have their maintenance office at Gurgaon, Haryana. Working under this company as an office assistant, I deal with record keeping of the company as such. I am acquainted with the present case. I was present when the contract agreement was signed between the parties, and I am also aware of the financial transactions that ensued as per this agreement. I am to state before this court that the defendant company has failed to comply to the terms and conditions of the agreement and has now refused to give cooperation to us. That is all I want to say. The third witness, your lordships will find on page 54.
Office assistant.
Office assistant. Then, my lords, can I just request your lordship straight away to come to para 4, my lords? Though paras are not numbered, so my lords, dots are there to the 4th dot. If your lordships could come to the 4th dot. I am also aware, my lords have that.
Yes.
I am also aware that this complainant company has been filed against the accused persons for non-performance of the contract work by the accused persons.
Yes.
Then further he says, I was present when the agreement dated 1/5/17 has been executed between the complainant and the accused persons. I have also appended my signature in the said agreement. I have appended my signature as director of the complainant company. On the strength of the agreement, my lord may skip that, your lordship may come to the next para. After the signing of the agreement dated 1st May 17, I have sold off my share to one Abhinav, and as such, I am not aware as to how the work had been executed between the parties. I also state that though I was the director, I have not personally visited the states where the contract work is to be carried out. As such, I cannot state whether the contract work has been executed or not by the accused company. I depose before this honorable court that I have come today to depose on to the extent that I have appended my signatures in the agreement dated 1st May 17 and that an agreement had been entered into between the parties. Now, my lords will kindly come to Lords will come to page 61. The first order which the magistrate records. My lords are page 61. This is an order of 15th of December 21.
Yes.
My lords, it says today is fixed for recording of statement of witness number 2, Shri Shashank A. Accordingly, the witness 2 appeared and his statement has been recorded. This criminal complaint petitioner registered as CR number so-and-so has been filed by the complainant, company Messrs. CSA Corporation, represented by its consultant Shri Santosh Kumar under 200 CRPC against the accused persons Green Lighting Private Limited and Gaurav Mamik for the offence of 406/420. This court had examined the complainant and the witnesses and enclosed along with the petition. Perusal of the case record shows that the accused persons are both residents of Gurgaon, Haryana, which falls outside the jurisdiction of this honorable court. As such, in compliance of section 202 CRPC, issue of process against the accused persons are postponed for further inquiry into the case. To this effect, OC West PS Dimapur is directed to make an inquiry into this complaint petition to enable the court to decide whether or not there is sufficient cause to proceed against the accused persons. To enclose the complaint petition along with all relevant documents. Your lordship may skip that. Then your lordships may come to page 63, where the report is submitted by the investigating officer. I have the honor to submit, my lords have that.
Yes, yes.
I have the honor to submit here with the inquiry report where it was found that accused Gaurav Mamik to Sushant Chabra. Now, my lord, Sushant Chabra is not even a complainant. He is not even the accused. He is not even named in the complaint. Lords, what is interesting is there are two accused. One is the company and the second is the managing director. But here he says, I've investigated the matter against Gaurav Mamik and Sushant Chabra. And then what further he says is, Sushant Chabra has approached the complainant for joint contract. The contract was therefore awarded to the complainant company, namely CSA Corporation Private Limited. In this regard, installation, commissioning, design, manufacture, supply, erection and testing, etc. for the standalone off-grid solar LED street light was awarded contract including maintenance for 5 years by the ESL Energy Efficiency Services Limited. Then your lordships will come to the next para. According to the statement signed by both parties, accused Gaurav was responsible for the complete execution of the contract. However, the accused person did not complete the work, and after abandoning the work, the accused could not be seen or contact him for at least 6 months. That is September 21, after taking the money amounting to so-and-so only. The contract work was done in 2 phases, 10th February 17 and 13th September 17 respectively. The amount for executing the work is 28 crores 23 lakhs 43,000. In this regard, after I thoroughly inquired of the instance case and it seems genuine, in support of which the statement of complainant, witness director CSA Limited is enclosed annexures 1, 2, 3. And your lordships may have my word for it. All the three statements which are recorded by the IO, there are substantial improvements. The 1-pager or half-pager evidence gets converted into 5 pages or 4 pages. And all 3 of them make in verbatim statements. There are marked improvements. This is completely ignored by the magistrate. their lordships know, I don't need to even plead that if there is a substantial increase or substantial, when you make statements, there are improvements which happen in the statements of the witnesses. Those witnesses or those testimonies cannot be believed at. That is what the apex court says. I've got judgments to that effect. So, my lords, my first defense with respect to why the order needs to be set aside is that there is no cause of action which had accrued in Dimapur. The installations, the commissioning, etc.
Just hold on, this page 62(3) report of the inquiry report.
My lords.
It doesn't say the accused, it says it was found that accused one, Mr. Gaurav Malik.
My lords.
Number two, Mr. Saurabh Sabra.
Sushant
Sabra is not an accused.
My lords,
You just see.
Yes, my lords.
According to this report, he wants to say is both these persons had, in fact, had or have approached to say that both these persons had approached for the contract. That's why his name has been given, not an accused.
But that is what I would show from the subsequent testimonies.
Is it an accused?
Yes, that's exactly what they're saying now. They want
Sushant
Sabra also to be summoned.
He's also an accused.
He is not an accused. I've shown so, my lords, why I showed the complaint first is, my lords, all the judgments that I'm carrying, my lords, all the judgments say that the complaint has to be seen. I've read the complaint. I've read the 3 testimonies which were.
You don't just give all the judgment. Give the judgment which is most relevant.
My lords, I will just read one para from all the judgments. Those judgments clearly, my first defense as I was submitting before my
first 10 letters you give.
Not
whole judgment.
I prepared a compilation. I'll take.
No, otherwise it's unnecessary. I mean, we're not on academic discussion. So you just give the relevant one.
I'll do that. But my first submission is that no cause of action had arisen in Dimapur. My second cause of action is it's a pure and simple case of breach of a contract. My third submission before your lordships is that if the witnesses make improvements in their complaint or in their testimonies which are substantial, then those testimonies cannot be believed at. And the fourth defense which I'm taking is, if I were to look at the order which the magistrate passes, your lordships will have the impugned order, my lords.
Yes.
Your lordships will have that impugned order. It is on page 95. It's annexure H. My lords, the defense which I'm again taking with respect to annexure H is there is complete non-application of mind by the magistrate while summoning me. So these are 4 grounds which warrant 95, my lords. This is an order of March 22, my lords.
This is the impugned.
This is the impugned order, my lords.
25. Okay.
My lords, if your lordships will come to para straight away, para 3 straight away, in compliance of this honorable court's order, a report from the office of the OC West PS Dimapur is being received today. Upon perusal of the inquiry report submitted by UBSIG EO West PS Dimapur, it is seen that during inquiry, statement of the complainant along with other witnesses had been recorded. It is also seen that the EO, upon examination of the statements of the complainant and the witnesses, had found that the instant criminal complaint case to be genuine. I have gone through the inquiry report. I have also gone through the criminal complaint and the relevant documents enclosed along with the criminal complaint petition, and upon being duly satisfied, inquiry report of the EO is taken into consideration. It is seen that it is a fit case. There is sufficient cause to proceed against the accused persons. Hence, finding prima facie case, cognizance is taken upon 406-420 IPC against the accused persons, namely Gaurav Mamik. Now, my lords, I've passed on to your lordships, my lords, written submissions along with the judgments. I'll take your lordships through all the 4 defenses that I've taken to establish that I have a bona fide case where I would plead your lordships to allow my petition and set aside the impugned.
Let's see the agreement.
Yes, I'm so grateful. So grateful.
Before that.
My lords will have that on 97, page 97. My lords have that?
Yes.
My lords, it says this is a joint venture agreement.
Do you agree that this agreement, there is no dispute?
There is no dispute about that.
Only, do we agree that there is a breach of contract?
There is a breach of, my lords, out of 10,000 lights, 7,000 were installed.
Okay.
Then COVID came. if I would
So
show.
according to you, I mean, there was something which you could not have performed due to intervention of,
Not only that, my lords are aware, when I talk about.
where is that condition?
My lords, that condition was not there because there was no COVID at that point of time. Nobody.
No,
could
no,
force it.
forget about the COVID, force majeure condition.
My lords, I'll come to that, but then all I'm submitting.
No,
is-
no, it may not be that relevant, but that's wanted.
Because I'll read the entire contract, I will show as to where the money was supposed to come, but before that, your lordships are aware. When I talk about 420, the apex court has repeatedly held that if at the inception, when I and you start to walk, there is no malified intention. There may be a fallout when we are walking together, but
Or
that
have-
fallout,
Or have you received that, the amount
no.
which was deposited?
No, I will show from your, I'm so grateful if your lordships will straight away come to the agreement.
Yes.
My lords, if your lordships will straight away come to page 100, which is clause 3, which talks about financials.
Okay. Hundred, yes.
Yes, my lords. Roman 1, if I could
Okay.
request my lords to come to.
Hmm.
3 Roman 1.
Hmm.
Because it says OADPL, that is the complainant, and UM Green, which is the accused number 1, will share the net profit or loss in the proportion of 50:50. It is agreed between both the partners that the profit shall only be distributed after receipt of last payment / installment towards completion of the project, which is supply, installation, commissioning of the entire contracted quantity from EESL, and only after securing the amounts towards performance bank guarantee and any other securities / guarantees given by OADPL to EESL, and securing the amount required for maintaining 10,000 units of standalone off-grid solar LED street light for the first year and so on. The division of project cost shall be on actual basis among the parties as mutually agreed and accepted. Now, this is important, lords. All the project costs, including purchase of goods, materials, expenses towards commissioning, transportation, installation, insurance, AMC, bank guarantees, security deposits, etc., shall be borne by the consortium and payments to be made by OADPL, which is the complainant. It is agreed that OADPL shall be entitled to cost of capital, that is interest on the amount invested prevailing at the prevailing bank rate, bank charges, etc., along with other project costs. Now, this is again important, my lords. It is hereby agreed that a separate bank account shall be opened by OADPL, which is the complainant, within 15 days from the signing of this agreement, wherein OADPL shall be the only signatory, and the intimation of the same shall be duly given to EESL within 30 days of signing of this agreement, so that the payments in respect to the subject tender and the contracts can be received in the said account only. Every single payment has been made by EESL to this account, which is solely being operated by the complainant. So where is the question of any payment being made to me? Then your
No,
lordships,
no, allegation is not the out of the contract amount payment from that, but what he said is that he has deposited 1 crore, and then from the company only, the complainant
my lords,
to the accused,
my lords.
he has received it.
No,
That is the allegation.
My lords, has he filed anything?
No,
Is there any document?
Is it not the allegation?
My lords,
He
allegation.
has said that 1 crore deposited and 60 lakhs something that you have
Well,
read it.
My lords, I
No,
would be.
allegations.
Yes, my lords.
Is it not?
It is incorrect completely. Has he
No,
filed?
whatever may be, the statement is there.
Yes.
The statement is that they have deposited 1 crore
My lords.
and then thereafter 60 lakhs, something, all those, they
They
have
have
made a
deposited
statement.
those bank guarantees.
That is
with
something
EESL.
different.
With EESL, he says that money was given to me. Now there is no proof filed. There is no document exhibited.
No, that is another thing. What I'm saying is that the allegation, the statement by the
My lord.
complainant is that
My lords.
he has deposited
My
1
lords.
crore
My lords.
to the which has been received and taken by the
Accused number 2.
That is the allegation.
And I've not done the work. That's their allegation.
Uh-huh.
But it is a case of breach of contract. They should have sued me. They should have sued the company. They should
Yes.
have recovered everything. Now, further, my lords, what is important is, if your lordships will come to the next page, page 62, where responsibilities are there.
It's okay.
My lords, just want to show one paragraph, the last paragraph, which is very important.
Page
Page 60, 102, my lords.
102.
My lords, which is part of the contract.
Yes.
The last paragraph.
It is made clear.
It is made clear that if any of the partner stroke party fails to perform their part of the obligation under the present consortium stroke joint venture agreement or commits the breach of duty stroke responsibility or is declared NPA insolvent, then the suffering partner has the right to claim loss of capital, profit, goodwill from the defaulting partner stroke party. This is agreed between us, my lords. Now he wants to, instead of going through the rigors of a civil case and trying to recover money from me, where he'll have to prove everything.
Shortcut.
Shortcut. So he files and the magistrate, I will, if your lordships now permit, I'll just take your lordship through the
You
best
just
judgment.
give me the latest judgment of Supreme Court. That's all.
Mullah,
By Justice.
I'll take your lordships through 1-1 judgment on all the 4 points and I'll leave it to that. Mullah, if your lordships will have the comparison.
I need only one judgment, or at best two.
Mullah, only I'll read only 1-1 judgment and
You just refer the latest.
yes. Mullah, if your lordships will see the index, I've given the page number of every judgment and the para which I'm relying upon. Mullah, the first judgment is starting from page 47. Your lordships will straight away come to page 112
Just
and 112. Citation is Mullah, Shubh Karan, Lakura versus State of India.
Okay. Page.
Mullah, page 112, the relevant para is there.
Shubkaran
Yes, Mullah.
Loharuka. Page.
Page 112, my lords, running page 112. Relevant paras are paras 59 to 63.
112.
Yes, my lords. 112, page 59.
No, I'm not getting it.
Your lordships, the page initial is on the right hand side corner, this side.
Yes,
Page 112, my lords. Para 59.
there's no 112. Okay.
My lords, it says, I have perused the aforesaid judgments and
Yes.
find that in all those judgments, it has been held that the jurisdiction can be conferred on the court either where the offense has been commenced or where it has been completed, and even where part of the offense was committed. Therefore, only pre-raised by the complainant that a meeting had taken place, just like in my case, my lords, had taken place in Delhi, office of the complainant, without giving any details as to when and for what purpose such a meeting had taken place, of which no minutes has been provided by the complainant, jurisdiction cannot be conferred in Delhi. According to the petitioner, the allegations made in the complaint, your lordship may skip that. Then your lordship may straight away come to the next judgment, page 148. This is Sri Krishna Polyesters Limited versus State and others. Page 148 and 149.
148.
My lords, paras 45 and 46. My lords, have that, please. Page 148.
148, yes.
Para 45, my lords. Therefore, the factual scenario would be that 3 pay orders stand delivered by the complainant to the accused persons at Mumbai. The complainant relies upon the agreements dated 17 September 99, recording that they have been executed in Mumbai. The bold version that certain negotiations took place at Delhi would, in my opinion, not confer jurisdiction on the courts at Delhi in view of the legal position that where offense of cheating and dishonest inducement results in delivery of property, courts within local jurisdiction whereof property was delivered by the person deceived or was received by the accused persons would be the courts which would have territorial jurisdiction to entertain the complaint. In the instant case, the pay orders have been drawn at ANZ Grindlace Bank, Mumbai. They have been delivered and received at Mumbai. Evidence pertaining to handing over and taking over is as per the agreement dated 17 September 99 executed at Mumbai. Thus, the courts at Delhi would lack territorial jurisdiction to entertain the complaint. Now, my lords, my second contention that with respect to a civil dispute, a criminal case cannot be filed. I would
No, according to you, jurisdiction should be where?
My lords, there are 3 states where we completed the agreements. They have an office in Delhi. They, when they file a response to my petition, they have said that I came, Gauram Mamik, who's the petitioner before my lords, came to Gauhati or came to Dimapur for the agreement to be signed. My lords, I have given the documents which I provided clearly show that on that date, I was in Delhi and I was traveling. There is an air ticket which I filed on record. Even this agreement was signed in Delhi because the complainant has an office in Delhi. I've said so on solemn affirmation that I've never traveled to Gauhati ever in my life. Or Dimapur, sorry, stand corrected on that. I've never traveled to Dimapur ever in my life. That affidavit is on record along with documents, whereas they have not provided even a single document to show. I'm also conscious of this, my lords.
But ask him to come. Ask him to visit.
Because once your lordships
a hub.
acquit him, he will be happy to come and see my lords Gauhati and my lords Dimapur.
It's a good city. It's a hub.
Because right now he is
Northeast, one of the hub in the Northeast.
because but he is fearful of
Business hub. Ask him to come.
I'll surely ask him to come.
We'll enjoy.
Milords, but there is one more thing, Milords. I am also conscious of this, that if your lordships were to hold that the jurisdiction is not of Dimapur, then your lordships can always take their complaint back and they will have to go to the court which has the competent jurisdiction. It's not a ground on which I can request my lords to consider my request for setting aside the impugned order, but nevertheless, it is one of the grounds which I've taken. The second ground of there being a civil case and not a criminal matter, I would request my lords to come to the judgments which start from page 257. I'll take your lordships through the first judgment. This is by 3 judges of the Supreme Court, my lords. The lordships will straight away come to
Yes, Rajendra.
my lords.
No, give the latest one.
261.
2021. You give the 2022 judgment.
My lords, it's of 2023. 309.
Ah,
My lords, it starts from page 309. Your lordships will
309.
relevant is 312.
309.
Yes, my lords. It starts from 309. I would request my lords to come to 312. Para 13, my lords.
309.
My lords. 312, my lords. Page 13, para 13.
Just wait. No, I'm talking about this 313.
312, my lords, para 13.
313.
312, my lords, para 13.
Just wait. Justice.
A breach of,
Honorable Justice Krishna Murari. Which?
my lords, it is just by Justice Bindal, my lords.
No,
It is
I'm
authored by
talking about this 2022.
My lords,
7 SCC, page 313.
my lords, but before that, I could just request you, I'll just show these two judgments. One is of 2023, para 13. It says a breach of contract does not give rise to criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction.
Para 12.
Para 13, my lords.
Para 13 of
Page 312, my
12.
lords.
Yes. It's second ground, it's okay.
Yes, my lords. Then, my lords, in this, the judgment which your lordships were referring to, Justice Krishna Murari, page 313, the relevant is, my lords, I'll just one second. Relevant would be page 328, 332, and 335. If I could request my lords to come to page 328. After relying upon all the judgments, this is what the apex court says, my lords.
$328.
Yes, my lords.
Okay. This court in G Sagar,
Yes,
para
my lords.
24.
328, my lords. Page 328, paras 24 onwards, my lords.
Okay.
It says this court in G Sagar Suri versus State of Uttar Pradesh observed that it is the duty and obligation of the criminal court.
It's okay, it's okay. I was just forgetting I forgot the citation. That's all. I've gone through it.
Milords, then the third ground which I've taken is for the improvement of the witnesses. That your lordships will find I've relied upon 3 judgments. If I could beseech my lords to come to page 443. Milords, I'm sorry. It should be page, it is Birla Corporation, page 461. Starts from page 444. I would request my lords to come to page 461.
Yes.
Paras 25 on this. Under section 200 of the criminal procedure, my lords have that. Under section 200 of the criminal procedure code, on presentation of the complaint by an individual, the magistrate is required to, my lords, I think these are judgments on without application of mind by the magistrate. So 225 says under section 200 of the criminal procedure code, on presentation of the complaint by an individual, the magistrate is required to examine the complaint and the witnesses present, if any. Thereafter, on perusal of the allegations made in the complaint, the statement of the complainant on solemn affirmation and the witnesses examined, the magistrate has to get himself satisfied that there are sufficient grounds for proceeding against the accused, and on such satisfaction, the magistrate may direct for issuance of process as contemplated under section 204 CRPC. The purpose of the inquiry under section 202 CRPC is to determine whether a prima facie case is made out and whether there is sufficient ground for proceeding against the accused. The scope of inquiry under this section is extremely restricted only to finding out the truth or otherwise of the allegations made in the complaint, in order to determine whether process should be issued or not under section 204 CRPC, or whether the complainant should be dismissed by resorting to section 203 CRPC on the footing that there is no sufficient ground for the proceeding on the basis of statements of the complainant and of his witnesses, if any. At the stage of inquiry under section 202, the magistrate is only concerned with the allegations made in the complaint. So your lordship will mark that in the complaint, or the evidence in support of the averments in the complaint, to satisfy himself that there is sufficient ground for proceeding against the accused. In National Bank of Oman versus Barakara Abdul Aziz, the apex court held the duty of the magistrate receiving a complaint is set out in section 202 CRPC, and there is an obligation of the magistrate to find out if there is any matter which calls for investigation by a criminal court.
Okay. Next.
Then, my lords, the last is this is, my lords, if I could beseech my lords to come to page 409. The judgment starts from page 409. I would request my lords to come to page 423, para 13. Para 30, my lords, page 423.
30.
Material contradictions. While appreciating the evidence, the court has to take into consideration whether the contradictions / omissions had been of such magnitude that they materially affect the trial. Minor contradictions, inconsistencies, embellishments, or improvements on trivial matters without affecting the core of the prosecution case should not be made a ground to reject the evidence in its entirety. The trial court, after going through the entire evidence, must form an opinion about the credibility of the witness, and the appellate court in normal course would not be satisfied in reviewing the same again without justifiable
It's
reasons.
okay. Is it of the stage of the cognizance?
This is my
This
trial.
case,
So
this
I could
case.
not, but here what they've done is, today, my lords, there are 4 witnesses.
You are
named.
relying on the cases where it was of
Yes, I could not find anything where there is a material, because, my lords, today my respectful submission to your lordships would be, there is not even a single document which has been filed to substantiate any of the allegations. I am said to, jurisdiction of Dimapur is said to be only because I signed the agreement. I've read to your lordship's judgments which say that mere signature of an agreement cannot result into jurisdiction, because the agreements were executed. Even if I were to say that it was registered in Dimapur, it was never signed by me because I've never traveled to Dimapur, or even for that matter to Gauhati. There are no documents. Third, these 3 witnesses who appear in the witness box when before the magistrate in support of the complaint make out a case. They themselves say it's a complaint which we have filed because of a breach of a contract. However, when investigation takes place, everybody in verbatim, 3 statements are recorded. In verbatim, they say the same thing, which runs into 5 or 6 pages, where they've again tried to bring out a case which falls, or which they, as per them would fall under 406, 420. Even if those evidences are to be seen, still it is a case of breach of contract.
Okay. So just give this judgment which you have relied. Just give them. I'll just.
Malaj, everything is there in the written submission.
No, I know.
Malaj.
But then just the cases which you have relied, just.
Malaj, I'll just mark them. After the arguments, I'll just mark.
Yeah.
In rebuttal, whatever my learned friend has to say, Malaj, I'll make submission and I'll mark it.
Anything else?
Well, once my learned
That's
friend
all.
submits, then I'll.
Your lordship, please watch, I am submitting my written submission, your lordship. In order to save time, your lordship.
Yes.
May I just take your lordship to my written submission, your lordship. Now, written page 2 and 3, I've given the list of dates from page 4. Page 4, your lordship. My lord has got it.
Yes, yes.
Page 4, this is the prayer of the petitioner for quashing the criminal complaint. And the ground for quashment, your lordship. First, as per the pleading and the reply affidavit, your lordship. The first is lack of territorial jurisdiction. Second is that allegation made in the complaint are false and there is no material evidence to prove the charge. 3, criminal proceeding under both section 406 and 420 IPC cannot coexist. That is in reply affidavit, but the petitioner is not present. My third ground, which you have taken in the reply affidavit, that criminal proceeding under both 406 and
The judgments which are relied upon are only in criminal, under criminal law, where the courts have said that there is no jurisdiction made out in this case.
okay. So I am taking this ground also. 406 and 420 IPC cannot coexist. Fourth ground taken, your lordship, the dispute is civil in nature. And fifth, in the reply affidavit that given in the pleading that it is complaint is filed simply to harass the petitioner, your lordship. Now, my submission, your lordship, and this is the legal principle laid down by the Honorable Apex Court, your lordship. Firstly, factors determining territorial jurisdiction in civil and criminal matters are different. The cause of action is not just place where the execution contract is executed, your lordship. Secondly, question of territorial jurisdiction should be raised before the court where the case is pending. Third, your lordship, lack of territorial jurisdiction is not one of the parameters to be considered for quashing of a case under section 42 of the CRPC, which my learned friend has himself admitted. Fourth, whether the learned court of CGM Dimapur has territorial jurisdiction to try the case will depend upon facts to be established by evidence and therefore cannot be decided without proper investigation and inquiry, your lordship. Fifth, a bare perusal of the complaint and materials available on record prima facie established a case against the petitioner, case number 2, and that while exercising jurisdiction under 482 CRPC, this honorable court does not examine the correctness of the allegation in the complaint, your lordship. Sixth, mere framing of charge under 406 and 420 by itself cannot be a ground to quash a criminal complaint or proceeding. Seventh, just because alternative civil remedy is available, your lordship, that does not mean that a criminal complaint cannot be maintained, your lordship. In support of this, your lordship, I have case laws, your lordship. I'll be placing case laws. Now, first submission, your lordship. Factors determining territorial jurisdiction in civil and criminal cases are different. Now, one of the main ground on which petitioner is questioning the territorial jurisdiction of the court of CGM Dimapur is that no cause of action arose in Dimapur because all the contracts were executed outside the state of outside Dimapur, your lordship. Now, may I and
Agreement was where?
agreement
Dimapur or Delhi?
in Dimapur, that is my contention, your lordship.
Yes.
But according to the petitioner, cause of action has not arose here, none of the cause of action, because all the work contracts executed were outside Dimapur, your lordship.
Just wait, just see let's see the agreement.
Agreement.
Page. And
97. And your lordship may kindly see. I'll just take your lordship to page 104. Jurisdiction. Lordship has got it?
Yes.
104. Subject to clause above, any action arising out of or pertaining to this agreement shall be initiated and maintained in the court of competent jurisdiction at Nagaland, your worship. So jurisdiction even otherwise, irrespective of whether it was.
Agreement is signed in Dimapur.
So your worship.
Criminal law, my affidavit, if your lordships were to see my affidavit,
No,
that is for a civil contract. My
consider-
affidavit, there is rejoinder affidavit, I have placed on record as to where I was on the date.
Yes.
And there are 3 dates. One is the date when the agreement is signed.
Sure, sure.
The second is the date when
It's okay. It's okay.
district.
I'll get back to you. It's okay.
May I take your lordship to page 11 of the petition? What is the ground for questioning the jurisdiction? Page 11?
It's okay. You continue the
Yes, page 11 of the petition, your lordship.
his petition.
Yes. Page 11. 7th line. This is the stand of the petitioner, 7th line, your worship. In criminal jurisprudence, my lord has got it.
Yes.
In criminal jurisprudence, the jurisdiction of the court is within the local jurisdiction of the court where the cause of action arose. Neither the criminal petition pending before the learned court below nor the inquiry report under section 2027 disclose any cause of action to have occurred within the jurisdiction of Dimapur, Nagaland. On this ground alone, pending CR number such and such deserve to be quashed and set aside. May I take your lordship to CRPC? CRPC. Section 179. Chapter 13 of CRPC, Chapter 13 CRPC provides for jurisdiction of the criminal code. 179.
Okay.
Offense tribal, where the act is done or consequence ensues. I am relying on this. When an act is an offense by reason of anything which has been done and of a consequence which has ensued, the offense may be incurred into or tried by a court within whose local jurisdiction such thing was done or such consequence has ensued. I am emphasizing on that, your worship. And next, 181, section 181. 181, your worship.
Yes.
May I read out? Place of trial in case of certain offense. Any offense of being a thug or murder committed by a thug or dacoity, whatever, with murder of belonging to a gang of dacoit, whatever, I am not this, is on 4. I am relying on 4, your worship. Any offense of criminal misappropriation or criminal breach of trust may be incurred into or tried by a court within whose local jurisdiction the offense was committed, or any part of the property which is subject to the offense was received or retained, or was required to be returned or accounted for by the accused person. Accordingly, your worship, it has been held by the Honorable Appeals Court that territorial jurisdiction in civil and criminal matters are different and depends on several factors, your worship. And to satisfy your lordship on that, may I refer to 2020, volume 10 SEC, your worship. Page 92, 2020, your worship.
2020.
Volume 10 SEC, page 92. Is a 3-judge bench, your worship.
Yes. Para
17. 20.6 and 20.11. Para 17. May I read out?
Yes, right. Kaushik Chatterjee.
Lordship.
Yes.
Kaushik Chatterjee. 17. As seen from the pleadings and the rival contentions, the petitioner seeks transfer primarily on the ground of lack of territorial jurisdiction. While the question of territorial jurisdiction in civil cases revolves mainly around cause of action, location of the subject matter of the suit, the residence of the defendant, etc., according as the case may be. The question of territorial jurisdiction in criminal cases revolves around place of commission of the offense, place where the consequence of an act, both of which constitute an offense, ensues, or place where the accused was found, or the place where the victim was found, place where the property in respect of which the offense was committed was found, or place where the property forming the subject matter of an offense was required to be returned or accounted for, according as the case may be. 20.6, Your Worship. 20.6. Where something is an offense by reason of the act done as well as the consequence that ensued, then the offense may be inquired into or tried by a court within whose local jurisdiction either the act was done or the consequence ensued, Your Worship. And para 20.11, Your Worship. An offense of criminal misappropriation or criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offense was committed, or any part of the property was received or retained or was required to be returned or accounted for by the accused, Your Worship. Therefore, unlike in civil matters, Your Worship, like place of cause of action is not the sole determining factor to confer jurisdiction on the criminal court, my lord. The place where the consequence of the criminal act will ensure or will be accounted for, that is also one of the determining factor to confer jurisdiction on a criminal court. So just because the contract work in question was executed outside Dimapur, Your Worship, that cannot be said that the court of Dimapur does not have territorial jurisdiction to entertain the criminal complaint, Your Worship. Now, may I refer to my affidavit in opposition? I'll just refer to one paragraph, Your Worship. Paragraph 3D, capital T, paragraph 3, capital T, Your Worship. Page 20, my lord.
D,
T,
T.
T for tiger. Page 20.
Yes.
That the work in question were executed in 5 different states, whereas the petitioner is a resident of Haryana having office in Delhi. The office of the respondent is in Nagaland. The meetings between the petitioner and the respondent took place at different places, including Nagaland and Delhi. Therefore, for the sake of convenience, only one state was chosen as jurisdiction for litigation, if any, in the written agreement executed between the parties on this date. Moreover, because of the intentional, dishonest, and fraudulent act and omission by the petitioner, and the green lightning, the respondent has been cheated and thereby consequence ensued at Nagaland. The respondent company files its income tax return at Dimapur, Nagaland, and hence wrongful loss due to cheating was caused to the respondent company at Nagaland. Therefore, the court at Nagaland will have the jurisdiction to try the criminal case as per section 179 CRPC filed by the respondent complainant. That further, section 181(4) of CRPC provides that any offense of criminal misappropriation or criminal breach of contract trust may be inquired into or tried by a court within whose local jurisdiction the offense was committed, or any part of the property which is the subject of the offense was received or retained or was required to be returned or accounted for by the accused person. Thus, with the respondent complainant's registered office in Nagaland, the criminal misappropriated amount was required to be accounted for at Nagaland as the respondent company files its income tax return at Dimapur, Nagaland, and hence wrongful loss due to cheating was caused to the respondent company at Nagaland. Therefore, the court at Nagaland will have jurisdiction to try the criminal case as per section 181 for CRPC filed by the respondent complainant. Accordingly, the criminal complaint petition was filed before the court of CGM Dimapur, Nagaland, which is registered and numbers as such and such, Your Lordship. Now, may I take Your Lordship to one show cause notice, which is Annexure Roman 1 in my compilation, Your Lordship, page 19 to my compilation. Page 9, page 19, Roman 1, Your Lordship. I have flagged it to my compilation.
Yes.
This is the show cause notice, Your Lordship, which the respondent or complainant has received from EESL, Your Lordship. To CSA Corporation, Lordship has got it.
Yes, yes.
Then address is Dimapur, Nagaland. Show cause, this is show cause notice 3, Your Lordship. Reference is there, show cause. And second paragraph, verification of installed light. I will not go through, Your Lordship. Note, last line, there is no verification done in 5 districts such and such. And I am emphasizing on next page, Your Lordship, the last paragraph. Kindly consider this letter as final notice. My lord has got it.
Yes.
And submit a reply along with corrective action plan within 1 week. That is still date 14 October such and such to carry out the remaining scope of works and complete the pending repair and maintenance. Failing which, this is the consequence, Your Lordship. EESL shall carry out the remaining work, including repair and maintenance from third party at risk and cost of CSA, Your Lordship. So the consequence of the criminal act, Your Lordship, action will ensue at Dimapur, where the company has a registered office respondent and will be accounted, Your Lordship. Hence the jurisdiction, Your Lordship. Now, petitioner himself admit that the respondent number 1 has a registered office at Dimapur. Therefore, it cannot be disputed. The consequence of the criminal act of the petitioner will also ensue or will be accounted for at Dimapur, Your Lordship. So, as per the provision of the CRPC, Your Lordship, the learned court of CJM Dimapur has jurisdiction to entertain the complaint, Your Lordship. Now, as regards execution of the agreement, Your Lordship, that contention of petitioner that he was never been to Dimapur or for that matter Gauhati, Your Lordship, and those are matters which can be which has to be taken up at the time of evidence, Your Lordship, not in an application of 482, Your Lordship. Now coming to my second point, Your Lordship, the others are very short, Your Lordship. The question of territorial jurisdiction, page 9, my written submission. My lord has got it. Page 9, Your Lordship. This question of territorial jurisdiction should be raised before the court where the case is pending. That is before the court of the learned CGM Dimapur, Your Lordship. And in support of this, I am referring to volume 2000, volume 10, SCC. 2000, volume 10, SCC 433. Just para 1, only 3 lines, Your Lordship. May I read out?
Yes.
This petition for transfer of 10K such and such cannot be on the ground shown in the course of such and such. Therefore, only a court of Lucknow can exercise jurisdiction. Question of jurisdiction is a matter which the petitioner will have to raise before the court where the case is now pending, Your Lordship, not before this honorable court under section 482 of the CRPC, Your Lordship. And the petitioner, Your Lordship, has never raised any objection as regards lack of territorial jurisdiction before the learned court of CGM, Your Lordship. The petitioner could have raised the issue of jurisdiction before the learned court of CGM Dimapur, but no, never, Your Lordship. Now, as per the law laid down by the Honorable Appeals Court, Your Lordship, now it has to be before the court where the case is now pending, Your Lordship. Now, on my third issue.
By this judgment, law has not been laid down. It's an observation.
No, Your Lordship. But then.
Para 1.
Para 1, Your Lordship.
It's not.
But based on this, the petition was dismissed, Your Lordship. Based on this observation, Your Lordship.
No, that's what I'm just saying.
Yeah, my lord.
It's not, you cannot call it a law.
Yes, not a ratio.
It's an observation.
Yes. But based on this, the petition was dismissed, Your Lordship. Third, Your Lordship. Lack of territorial jurisdiction is not one of the parameters to be considered for quashing of a case, Your Lordship. Because the lack of territorial jurisdiction, Your Lordship, does not go into the root of the matter, Your Lordship. And this also is considered by the counsel for the petitioner, Your Lordship. But
So skip it if
I'll
he,
just
if
skip
he
it.
is
Yes, Your
considered.
Lordship, Your Lordship, because that cannot be a ground for quashing, Your Lordship, that has been considered. Now, fourth, Your Lordship, the issue of territorial jurisdiction depends on the facts to be established by evidence, Your Lordship. And in support, to support this, I am referring to 1970, Volume 1 SEC 521. Para 12 to 24, 12 to 14, Your Worship. Short paragraph, 6-7 line only. 12 to 14.
Yes,
May I read out?
yes.
In the present case, the appellant denies that there was any special entrustment of any property or that he was holding any property in a fiduciary capacity. It is neither possible nor desirable to express any opinion on the merit of such a plea. It is not possible to do so because the facts are not in possession of the court, and furthermore, the facts cannot be before the court without proper investigation and inquiry. It is not desirable to do so because if any such opinion be expressed, it may prejudice or embarrass either party. The plea as to lack of territorial jurisdiction cannot also be decided on the materials, nor can an opinion be expressed on that question because it needs to be established by evidence, Your Worship. So it is made clear that all pleas and defense are left open to the appellant, including the question whether there's any special entrustment of any property of the appellant and the territorial jurisdiction of the court, Your Worship. So the plea of regarding territorial jurisdiction, Your Worship, needs to be established by evidence, and it cannot be decided in the application under section 42 of the CRPC, Your Worship. Now, fifth, Your Worship. As regards the allegation in the complaint. Now, a bare perusal of the complaint and materials available on record prima facie established a case against the petitioner, accused number 2, and that while exercising jurisdiction under 42, the Honorable Court does not examine the correctness of the allegation in the complaint, Your Worship. Now, in order to ascertain as to whether a case is made out against petitioner or accused number 2, the court is required to take into consideration the complaint along with the statement of witnesses as well as the inquiry report, Your Worship. Section 203 CRPC, Your Worship. Because everything has to be taken up, the whole package, Your Worship. Now, on that, may I also refer to one case law, Your Worship, which I have annexed as Annexure 3, page 32. It is from SEC Online to 2022, SEC Online, page 482. And in my compilation, Your Lordship, Annexure 3, Your Lordship, page 32.
Yes.
Para 31. There's Rambir Upadhyay,
Rambir Upadhyay.
my lord. Para 31, my lord, I'll just skip to that some other cases have been quoted. 1, 2, 3. Fourth subpara, next page, Your Lordship. Thus, it may be safely held. Next page. My lord has got it.
Yes, yes.
Thus, it may be safely held that in the following cases, an order of the magistrate issuing process against the accused can be quashed or set aside. Where the allegation made in the complaint or the statement of the witnesses recorded in support of the same, taken at the face value, make out absolutely no case against the accused, or the complaint does not disclose the essential ingredients of an offense which is alleged against the accused, Your Lordship.
Yes.
Now, on this similar line, Your Lordship, I may refer to Bhajanslal's case, which is reported in 1992, Supply 1 SCC, page 335. Bhajanslal case. Bhajanslal.
Do we? Bhajanslal, do we record?
Yeah, para 102, Your Worship. Yes, while taking cognizance, your lordship, the measure has to take into consideration the complaint, the statement of weakness, the inquiry report, and all the materials which were before the court, your lordship.
102.
102,
102.
para 102.
It's okay.
Yes, I'll just read the three paragraphs, 1, 2, and 3 in where the allegation made in the first information report or the complaint, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute any offense, lordship. 2, where the allegation in the first information report and other materials, your lordship, if any, accompanying the FIR, do not disclose anything. 3rd, whether the uncontroverted allegation made in the FIR complaint and the evidence collected in support of the same, which will include even the inquiry report and the statement recorded during the inquiry, your lordship. Now, in the present case, your lordship, in the complaint, from the complaint, the statement of the complainant, witnesses, and the inquiry report, a prima facie, your lordship, clearly established a case against the petitioner to initiate criminal proceeding under the relevant provision of law, your lordship. Now, may I take your lordship to complaint, just few paragraphs, I'll take your lordship, complaint, page 42 of the petition. May I take your lordship to the petition? Page 42. Para 11 and 12. This is the complaint. Relevant page is 45, paragraph 11 and 12.
Yes.
That the accused number 2, having hatched a plan to deceive the complainant, induced the complainant at Dimapur and entered into consortium, joint venture agreement, that is such and such at Dimapur in respect of the above said electrification work, and for submission on behalf of the accused number 1. But after obtaining the work and taking the responsibility of maintenance of the work, as expert, and after collecting share, intentionally ignored the work of maintenance pertaining to the electric light commissioned in the UP, Bihar, and other states. That the accused number 2 has also collected huge amount from the complaint. This is not regarding transaction of the bank account which the petitioner is referring to, your lordship. For the sake of maintenance of the commissioned electric light, which the complainant paid, even borrowing from other sources to keep intact the goodwill with the complainant company, but the accused number 2 collecting such huge amount in the name of the maintenance of the light has not employed proper and adequate employees and abandoned the maintenance work, collecting money from the complainant inter alia for employee salaries, your lordship. Now, may I take your lordship to page, the statement of witness, page 49. Statement of witness number 1 starts from page 51, your lordship. I'll read out para 5 to 8 and 10, the short paragraph. In the year 2017, in the month of May such and such, we have entered into an agreement with such and such. This is the petitioner's company. In the said agreement, it has been agreed between the parties that MSUM Green Lightning Limited shall provide 5 years maintenance service in connection with the solar lighting installment made by a company in 7 states. 6, in view of the agreement entered between my company and such, a bank guarantee was also submitted to the department, EESL, Government of India. 7, 2 bank guarantees totaling to an amount of 1 crore such and such has been deposited in the month of September to the department. 8, the accused company, after entering into agreement, had provided his maintenance service for 1 year and had also during that time taken an amount of rupees such as such 80 lakhs from time to time from the complainant. Thereafter, the accused company has failed to provide his service as agreed upon on the pretext of one or the other reason. 10. The complainant company has also received termination letter from EACL to the effect that the work has not been executed. Hence, this criminal complaint is before this honorable court. Intervention as the bank guarantee amount such and such shall be forfeited, our company will be blacklisted, your lordship. Now, next statement, witness number 2, page 54. Para 5 and 6. I'll just read out the short 2-3 line only. Para 5 and 6, your lordship. I was present when agreement dated such and such has been executed between the complainant and the accused person. I have also appended my signature in the said agreement. I have appended my signature as a director of such and such. On the strength of the agreement entered on, the complaining company has also deposited more than ₹1 crore as bank debt guarantee against a contract work for installation of solar light and maintenance, and the same with the accused company. However, the accused company has failed to perform their work. As such, the criminal complaint petition has been filed against the accused company, Your Lordship. Now, coming to the inquiry report, Your Lordship, at page 63. I'll just page 63. I'll just read out this is the inquiry report, last paragraph. In this regard, I have thoroughly inquired into the instance, and it seems genuine, and in support of which statement of such and such is enclosed as annexure 1, 2, and 3. This is the report of the inquiry, and the complaint was found to be genuine by the inquiry officer, Your Lordship. Now, before the inquiry officer, statement was also given, Your Lordship. We starting from page 64. Sixty, 64, 66, 67, Your Lordship. May I just read out 64, Your Lordship? There is just 11 paragraph. The third paragraph. In the year 2016, accused Mr. Such and such with dishonest and fraudulent intention to cheat our company, approach us and represented the company has an unchallenged expertise in the supply, installation, commissioning, and annual maintenance of the standalone off-grid solar LED street lights. Last line. Accused induced us, page 64, last line. Accused induced us to act as the financial partner, page 65, and they would remain technically responsible for the complete turnkey execution of the contract. We were fraudulently and dishonestly induced to enter into a consortium agreement dated such and such, wherein Green Lighting Limited through Gaurav Mamik became a technical partner, and our company through me the financial partner, Your Lordship. Page 66, just relevant portion. We duly furnished the security deposit performance guarantee on behalf of the consortium in favor of such and such, bank guarantee such and such. For second LOI issued on such and such of standalone green street lights were again furnished another security deposit performance guarantee in favor of ESL amounting to such and such, bank guarantee number such and such on behalf of the consortium. Now, we provided complete financial support to the accused for both the project. But since the intention of the accused was dishonest and fraudulent, complaints and glitches started emerging in the supply, installation, and performance of the solar LED street lights from early stage. Initial complaints were regarding verification of uninstalled solar LED lights, for which complete payment was made by us for the required supply of the solar LED lighting system. Complete payment was made to the petitioner, the accused, PV module such and such, to the accused as per the invoices rate charged by them, inclusive of the profit share in advance. As per the rate charged by them, payments were made, Your Lordship. The accused has also charged for the installation of the street lights along with the profit margin for which all payments have been made to them. But the accused failed to install the same, thus causing wrongful loss to us and wrongful gain to the accused. ESL informed us total number of such unverified installed solar LED street lights as approximately 3,430. In spite of several requests, the accused failed to provide the complete statement of material used in the project, location-wise, for reconciliation, even after receiving all payments against the invoices raised by them. We also received complaint regarding the maintenance of the solar LED street lights covered under AMC as specified in the award, and maintenance was to be undertaken by the accused. We requested accused multiple times, especially accused Gaurav Mamik, the petitioner herein, to take corrective measures immediately. The accused initially informed us that all other solar LED street lights have been installed as per the tender and promised to get verification of the same done and get the complaint regarding maintenance rectified at 10-2. However, none of which was done, again showing their dishonest and fraudulent intention. The security deposit performance guarantee submitted by a company in favor of ESL, retention money with the department assets are in danger of forfeiture because of the non-performance, intentional, dishonest, and fraudulent act and omission of the accused.
Just wait. No.
Thus, the accused from the very beginning fraudulently misrepresented and took great advantage of us not being technically involved in the project. Accused took their profit share in advance through all the invoices raised on the complainant and received payment with no financial investment. After over invoicing accused with dishonest and fraudulent intention, did not attend to the project, leaving complainant in a situation where EECL is likely to forfeit the bank guarantee, penalize and blacklist and ban the complainant, not release their pending bills, unbilled payment, retention of money, etc. Consequence will ensue at Dimapur, Your Lordship. Accused had dishonest and fraudulent intention from the very inception, and they have cheated us by making false promise, dishonest and fraudulent misrepresentation, Your Lordship. Now, page 69, Your Lordship. This is by statement of the director, Your Lordship. Now, more or less same line, Your Lordship.
Okay.
But regarding that thing, that force majeure, Your Lordship, which the petitioners emphasize. May I take Your Lordship to page 86?
76.
Page 86. This is also the statement of the complainant, Your Lordship. Page 86. The third paragraph, that even after first COVID wave, my Lord has got it?
Yes.
That even after first wave of COVID-19 was over and continuous follow-up by a company did not yield any corrective action by accused. Even after the second wave of COVID-19 was over, Your Lordship, nothing was done by the accused.
So it's a breach of contract.
No, Your Steve, the intention, the intention was there, Your Lordship, right? Had it only been because of COVID, Your Lordship, immediately after first wave, second wave, they could have taken some corrective measures, Your Lordship. But no. That is what I'm trying to impress upon Your Lordship. If that is the case, Your Lordship, by now they could have already taken all the corrective measures. But from the very beginning, Your Lordship, their intention was not good, Your Lordship. So, and regarding this thing, the improvement in the statement, Your Lordship. May I take Your Lordship to page 94?
94.
Improvement of statement of witness. Because this is a statement which the complainant has given. May I read out?
Yes.
The above statement in detail, as the same has been prepared, is detailed as the same has been prepared after going through all the relevant documents, Your Lordship. At the time of filing the complaint, I could not write all the facts as the company was in the process of collecting all the relevant documents and details in addition to getting the accounts vetted through financial auditing, Your Lordship. So it is not a case of afterthought or like improving the statement. No, at the time when the complaint was filed, Your Lordship, all the details were not there, Your Lordship. Now, coming to my next point, Your Lordship.
These statements which you have shown, it's a statement before the inquiry.
Yes, inquiry officer, yes.
Inquiry of,
Yes, all the
Before
details were given.
and which he has relied is at the time of complaint.
The improvement, but these are all facts, Your Lordship. These are all facts. The transaction account, whatever, these are all matter of record, Your Lordship. Now, therefore, Your Lordship, it cannot be said that there is no material, Your Lordship, evidence to prove the charge against the petitioner, Your Lordship. Now,
Improvement, I'm not, this court is not that convinced. We may determine on other issues other than the improvement. It may not have much bearing. Prima facie, according to this court.
this is our record, Your Lordship, based on record, Your Lordship. Now, may I take Your Lordship to the case number Ranveer Singh, Your Lordship? Yes. NHA 3, page 32 citation. 2022 SEC online.
Yours.
My compilation, Your Lordship. NHA 3, page 32, Your Lordship.
Annexure 2,
Annexure 3, your lordship.
3. Okay. This you have referred already.
I have referred, but I would like to refer to two separate paragraphs, para 32 and 39. Earlier, I referred to para 31, your lordship.
Okay.
Now, I would like to take your lordship to para 32 and 39. Para 32, may I read out them?
Yes.
As held by this court in state of Andhra Pradesh versus such and such, the High Court, while exercising jurisdiction under 482 of the CRPC, would not ordinarily embark upon the inquiry as to whether the evidence is reliable or not, or whether there is reasonable possibility that the accusation would not be sustained, your lordship. Para 39.
Okay.
In our considered opinion, criminal proceeding cannot be nipped in the bud by exercise of jurisdiction under section 482 of the CRPC, only because the complaint has been lost by a political rival. It is possible that a false complaint may have been lost, whatever. The 7th line, your lordship, relevant line. In exercise of power under section 482 of the CRPC, the court does not examine the correctness of the allegation in a complaint, except in exceptional rare cases where it is patently clear that allegations are frivolous, or do not disclose any offense. Now, in my respectful submission, your lordship, and as per the complaint, the statement of the complainant, witnesses, and the inquiry report, your lordship, and the statement which has been given by the complainant and the witnesses before the inquiry officer, your lordship, there is sufficient material, your lordship, to establish the charge against the petitioner, your lordship. Now, my 6th issue, your lordship. Mere framing of charge under section 406 and 420 cannot by itself be a ground to quash a criminal proceeding complaint, your lordship, because they cannot coexist. For a moment, may I take your lordship to CRPC? Section 221.
Yes.
May I read out? Where it is doubtful what offense has been committed. If a single act or series of acts is of such a nature that it is doubtful which of several offenses and facts which can be proved will constitute, the accused may be charged with having committed all or any of such offenses, and any number of such charges may be tried at once, or he may be charged in the alternative with having committed one of the said offenses, your lordship. Illustration A. A is accused of an act which may amount to theft. Lordship has got it? Or receiving stolen property, or criminal breach of trust, or cheating. He may be charged with theft, receiving stolen property, criminal breach of trust, and cheating. Or he may be charged with having committed theft, or receiving stolen property, or criminal breach of trust, your lordship. In this case, in this respect, your lordship, our honorable court has the occasion to examine this, your lordship, which is reported in Pinku Roy's case, your lordship, in my citation, Annexure 6, Annexure 5, your lordship, page 47. Pinku Roy and 4 others, your lordship. Page 47, my compilation, lordship. My lord has got it.
Yes.
Paragraph 16 to 22, these are short paragraph, but 16. May I read out?
Yes.
While looking at the ingredients of the offense under section 420, 406 IPC, there is no doubt that on the same set of facts, there may not be conviction of a person simultaneously under both section 420 and 406 being cheating and criminal breach of trust. But there is no difficulty in taking cognizance or framing charge under section 406 and 420 IPC simultaneously against same person on the same set of facts as framing of alternate charges permissible under section 221 CRPC, which reads as under, Your Lordship. I've already read it, Your Lordship. Now, para 17 is the illustration. 18, Your Lordship. Para 18. The illustration A to section 221 CRPC thus makes it evidently clear that simultaneous framing of charge for the offense of cheating and criminal breach of trust is permissible on the same set of facts as indicated in section 221 CRPC. When it is permissible to frame alternative charge simultaneously for offense of cheating and also criminal breach of trust on the same set of facts, if it is doubtful as to which offense has been committed, in my considered view, there is no difficulty in taking cognizance under all the sections which prima facie appears to be attracted by the allegation made in the complaint, or when it is doubtful or there is confusion as to which of the several penal provision will be attracted, notwithstanding the facts that all the offenses may not be proved finally, or conviction for all the offense of which cognizance is taken may not be possible at the conclusion of the trial. When it is permissible under the statute to frame alternative charge for the offense of cheating and criminal breach of trust, taking cognizance by the magistrate on the same set of facts alleged in the complaint for offense both under section 406 and 420 IPC cannot vitiate the entire proceeding or trial, nor a complaint deserves to be quashed solely on the ground of taking cognizance under 406 and 420 IPC simultaneously on the same set of facts. We therefore follow from the above discussion is that though conviction of an accused for offense of cheating and criminal trust may not be possible on the same set of facts, there should not be any difficulty in framing alternative charge or taking cognizance of offense under section 420 and 406 simultaneously. Being of the above view, I have no hesitation to hold that taking cognizance under section 420 and 406 IPC at the same time, the same set of fact cannot be held to be impermissible under law.
We'll finish before one.
Yes, the last ground, Your Worship.
Yes.
On the ground that the dispute is civil in nature.
Okay.
Now, just because alternate civil remedies are available, Your Worship, that does not mean that criminal complaint cannot be maintained, Your Worship. Now, in support, I am referring to 2014, volume 3 SEC. 2014. 389. Para 12. Para 12, I will just read out the relevant portion, Your Worship.
Yes.
The learned counsel for the respondent is correct in contending that in a given set of facts which may be civil or a civil wrong, or also a criminal offense, and only because a civil remedy may also be available to the informant, Your Lordship. That itself cannot be ground to quash a criminal proceeding, Your Lordship. Now, another judgment, 2001, Your Worship, on the same line, 2001, volume 2 SCC.
Now, when we have this 2014, why should go for 2001?
2001, volume 2 SCC,
Yes.
page 17, para 8.
Yes.
Second line. However, it is also a settled law that facts may give rise to a civil claim and also amount to an offense. Merely because a civil claim is maintainable, that does not mean that criminal complaint cannot be maintained, Your Worship. On that, Your Worship. Now, in the pleading, Your Lordship, the petitioner has taken the ground that the complaint is filed simply to harass, Your Lordship. So just on my additional submission on that, Your Lordship, while considering this aspect of the matter, Your Lordship, the antecedent past history of the petitioner may also be taken into consideration, Your Lordship. Because it is in the past, there was an occasion when the company of the petitioner was blacklisted, banned by the ESL, Your Lordship, which I have annexed in my affidavit of opposition, Your Lordship. Page 28. These are the past record of the petitioner, Your Lordship, petitioner company.
I think, is it necessary?
Page 28.
Whatever he has said, that would be accepted, not
Lordship.
to file a complaint only to harass.
Yes, yes. In a pleading, it is in a pleading, it is there, Your
Okay.
Lordship. And in fact, Your Lordship,
I don't think it's that significant. What do you say?
Milords,
It is
if
not that
it's not resting
significant.
it,
Milords,
The complaint, you said that it has been filed to harass the.
because Milords, I would show from the documents, I will show how. If once my learned
No,
friend,
no, whatever you have
Milords, I
to show,
want to-
we'll have to finish before.
Milords, I will take just 5 minutes after my learned friend.
No, no, he is not complete. So what I am saying, he's submitting on the point of the.
The harassment.
that
Milords, again,
harassment.
with all humility at my command,
Yes.
we had to file a section 209 application in this. Because he has said that I was there in Dimapur to sign that agreement on a particular date. I have annexed along with my rejoinder affidavit as to where was I. I've given the
It's okay,
tickets,
it's okay.
air tickets. Air tickets show that I was traveling from
Okay.
Delhi to Chandigarh.
Okay, okay.
So where is the question of me coming to Dimapur to sign the document? Milords, and your lordships will also keep one thing in mind.
But it
There-
shows, it was signed with at Dimapur, your annexure.
No, my lords.
Agreement.
Because I said I gave it in Delhi. I have given the WhatsApp chats between me and the director, which show that I signed it in Delhi.
So this was registered, agreement registered at
At
Dimapur.
Dimapur by the my lords, 1st of December, I think is the date. First
It's
of
okay,
May.
it's okay, it's okay. Let him complete.
and coming to the petition, page number 107, Your Lordship.
Yes.
Proceeding is also pending against the petitioner company before the National Company Law Tribunal. It is filed by another company, Your Lordship. These are their own documents.
10.
107, Your Lordship. They're proceeding under insolvency in bankruptcy court. 107, Your
Okay,
Lordship.
okay.
107.
This is against,
Against the petitioner's company, Your Lordship, by another company.
okay.
So this is their documents, Your Lordship. So this is not the first instance, Your Lordship. So the conduct of the petitioner, the past conduct of the petitioner may be also taken into consideration while your Lordship consider whether this petition.
What is the case there in the
There was
company law?
insolvency where the
National Company Law Board.
for payment of money, Your Lordship, for recovery, Your Lordship.
Okay.
Now, Your Lordship, now regarding the,
According to you, it's not only you.
yes.
There are other persons also who has made a complaint and
Yes. Like, and on the excess of jurisdiction of 482, Your Lordship, Bhajan Lal's case, Your Lordship, paragraph 103, Your Lordship.
no, that is the.
That is the thing. So in my respectful submission, Your Lordship, the no interference called for. There is no infirmity on the order passed by the learned CGM Dimapur taking cognizance, Your Lordship. The petition is liable to be dismissed, Your Lordship. I am obliged, my.
Lords, can I request my lords to come to the rejoinder affidavit that I filed? Affidavit in reply that I filed.
Your name is there, Mr. Learned Counsel.
In the cost list. No, I think.
Milords, my colleague's name is there. We are doing the matter.
Has he?
Mr. Joshua's name is there.
You are a senior lawyer?
No, I'm not a senior.
In
I'm just
that case-
assisting Mr. Joshua.
Okay,
I'm just assisting Mr. Joshua.
you need to file, in fact, as a procedure.
Milords,
I'm not saying that I'll not hear you.
Actually,
Milords,
yeah.
You need to file, I mean, that
Yeah.
has to be maintained.
I'll do that.
Actually, I was.
It's already filed,
Huh?
but because their names are not in the data maintained by the registry.
No, that's I'm asking, whether you have filed
It's
or
filed,
not.
filed. No.
Can I?
Because we have to maintain
Milords, I will.
the procedure, I mean,
Today itself,
otherwise,
if it is not filed, I will ensure that. Can I request my lords?
you
to have the-
ensure it is filed.
My lords,
It's already filed, Your Lord.
Okay,
Milords, the reply affidavit that we,
okay, 5 minutes, huh?
5 minutes, by the way.
reply affidavit.
Yes, my lord.
It's bigger than your petition. Huh?
Well, there are certain documents which I need to, my lord, may straight away come to the documents. The first document which will also be found.
Yes. 16.
My lord. So
Okay.
your lordship will keep one thing in mind, the agreement is dated 1st May. It is attested by the district and session judge on the 11th of May. It is registered on the 12th of May. So my lord will have the first document which shows that on 1st of May I was in Delhi. Your lordship will have the second document which shows that the date of registration, 10th of May I was still in Delhi. And your lordship will see that page 18 shows that on 12th of May I was traveling. 10th of May itself I had taken a flight and I was not in Dimapur. This flight would show that I had taken the flight from Delhi to Chandigarh.
So according to this agreement, it's not, it's a fact.
My lord, I will just.
Since you have not signed it.
My lord, I will show as to why where this agreement was signed. If I could request my lords to come to straight away. My lords, annexure, this will be page. Just one. This one.
That's right. So according to you, but these documents that when the agreement was signed,
Yes, my lord.
you were not at Dimapur,
I was not at Dimapur.
and you have put your signature while sitting at Delhi.
Delhi, because their administration is at Delhi. That's what their documents say. They have branch offices. One of the branch offices.
But why it has to be registered here?
I don't know, because
Dimapur.
maybe because they.
It's an agreement between you and
And the
complainant.
respondent one. But they have got it registered here. I did not have an issue. In 2017, I could not foresee that they would lodge a criminal complaint.
Okay.
Now,
So you have will accept it that you are not
Then, my lord,
there
there
at
are
the
two
time
things.
of.
There are two things, my lord.
Okay.
One is, what has been repeatedly argued is that where the act was done and what are the consequences which are ensued. Now, everything, their main head office, or that's what their documents say, is in Delhi. So if anything were to ensue, it was in Delhi. And the second, my lords, it is their own admitted case that in 3 different states, not in Nagaland, not in Gauhati, but in 3 different other states that the agreements were done. So these supplies were made there. Everything was done there. This is with respect to the cause of action. Second argument which has been made by my learned friend is that both civil and criminal case could be filed. I'm in complete agreement with my learned friend. That can be done.
Would you not agree that as a prudent businessman,
My lord,
when you enter into agreement,
my lord,
you have to put your signature,
my lord.
and will you not vigilant enough to know that where this agreement will be registered?
Look, at that time, there was nothing for me to doubt them. I was doing the business. It's only till COVID. And what my learned friend read before my lord.
You are not doubting them, they are doubting you.
Because I did out of 10,000, 7,000 odd were supplied, installed, commissioned.
Okay.
3,000 were not there.
Okay. Show me what you want to.
Lordship, I may be allowed to supplement on one point. About
Only
a past-
one point, huh?
Just 1 minute, Lordship.
Huh.
About a past section of
I'm
the
counting.
accused person, Lordship, which has been, allegation has been made in the affidavit filed by the respondents. Now, Lordship, no loss has been caused to the respondent in any manner, Lordship, that I have proved in my affidavit in reply. They have stated and mentioned about the proceeding before which is
Company law board.
yes, Lordship. Now, Lordship, there also, Lordship, it has got nothing to do with this case. Number 2, Lordship. At the time when the action was, my company was blacklisted. Lordship, at that point of time, it has got nothing to do with this case. No loss has been caused, and I have, by way of documents, I have shown in my affidavit in reply, Lordship. The other thing is about all the materials on record, which my learned senior friend for the respondent number 1 has submitted, Lordship. In fact, your Lordship will appreciate this fact that at no point of time, Lordship, the material ingredients, which is a must. Material ingredients must be there, Lordship. Even before a court, before the police, no material ingredients. It's just in verbatim, just by a statement. Can there be said that there is any material documents on record to show incriminating evidence against the present accused person, the petitioner lordship. On this lordship, I may be allowed to place one judgment which is already there, but the 2011 13 SCC lordship, page number 379.
2011.
2011 13 SCC, page 412, paragraph 34 and 37, lordship. In brief, I may be allowed to read from what I have prepared, lordship, just one line, lordship.
Get 1 line, yes.
Paragraph 34, in short, the principles enunciated shows that the complainant must disclose, it is not an option, lordship, must disclose relevant material ingredient of sections 405, 406, 420. So, lordship, where is the material ingredient, lordship? Not even one, lordship. If there is a flavor of civil nature, the same cannot be agitated in the form of criminal proceeding. Paragraph 37, in short, lordship, even if we admit that allegations in the complaint do make out a dispute, still it ought to be considered as merely a breach of contract, and the same cannot give rise to criminal proceeding for cheating unless fraudulent or dishonest intention is shown right from the beginning of the transaction. So when no loss has been caused to them, allegations made have all been disproved by way of documentary evidence in my affidavit in reply, lordship. This is just a breach of contract where no criminal proceeding is called for, lordship.
Okay.
Section 221 has been taken off and judgment is also taken off. Section 221 comes under that is penalty which was charged by the magistrate, not of family, and there we have all the family.
Okay.
Not the violation of the market. I've already seen.
Not all the cases, the cases which you are relying.
Yes.
So, we'll reserve the judgment, CAB.
So.
Sorry for the indulgence. My presence may be recorded.
Respondent number?
Responding
You want to make any submission?
No. Yeah, just happened.
So this court will take your role. Heard, Mr.?
Dhanesh.
Huh?
Mr. Joshua and Mr. Dhanesh.
No.
My name is Dhanesh.
Dhaneshwar.
Dhanesh.
So and so. And Mr. Joshua, learned counsel.
Love my colleague.
And so. For petitioners.
Love.
And also her
TB Jamir.
TB Jamil, learned counsel. For the respondent. One or what?
For one.
For one. You are two. Mr. K. Angami. Learned. PG. Sorry. VG Momi. I just sorry. For learned PP. PP for the state of Nagaland. For respondent number 2. Hearing concluded. Judgment CAB. Judgment reject.
Deeply obliged, lordship. Deeply obliged.
Now I am overburdened.
Lordship, vacation is there, lordship.
Don't have vacation and holidays for judges.
Lordship.
Great.
Obliged, lordship.
Admission
But we will mention it after the vacation because argument will never conclude. If the honorable judge wants to take the matter slowly, it may take at least 2 days to finish the argument. The copy, kami get got dibo. Ito nalagya kan do ulay dibo. Kali lagya la the refer kurala na mark unit. Yes. Both of you, please do it. Both of you. Bye. Bye. My junior, you please mark the judgments referred.
Computer section after break.
Next. Next.
Your Lordship, item number one, we have decided to
After
reflect
4 weeks.
24th July,
Uh,
because it will take a long time.
on the prayer of Mr.
Mutually,
Huh?
parties, mutually,
Ah.
mutually.
Mr. Imshok, that addition AG and Mr.
KV.
KB. KB what?
I'm sitting on behalf of my senior Joshua.
Stop. On the prayer of so and so, list this matter on 24/7/20. Matter is about what?
This is regarding the Woolish card,
Huh?
Woolish card. They are
Wooli-
claiming skill of pay at par with the regular
Oh, oh.
police. So it will take long time.
So Mr. Joshua was insisting
Yes.
that it should be heard and. Okay,
May I please, your lordship? Lordship, I would like to mention item number 19.
19,
Yes.
after 6 weeks,
Lordship, it can be fixed after vacation.
okay,
Otherwise, your lordship, it's a short matter.
okay. What is the matter?
Lordship, the petitioner hearing has appeared the interview.
Hmm.
Terribly failed the interview.
Okay,
Now he is here before the court.
Madan Lal,
Lordship, exactly, my lord.
Madan Lal, and then what is the latest?
Lordship, in this case, I'm assisting my senior.
Mr. Jed Zimome,
Yes.
she was here yesterday.
She
Where
was-
she is?
She was here even
This morning.
Okay,
Because it's-
anyway, his senior is not there.
Lordship, I leave it to now.
Mr. So-and-so, learned counsel appearing on behalf of MS Jed Zimome, learned counsel for the petition. President matter may be listed after summer vacation. We are not being opposed by the learned counsel to the respondents. List this matter after summer vacation.
Lordship. Pleasure, Lordship.
Lordship. Wow. In item number 17, Lordship, this matter was wrongly mentioned, Lordship, in the morning. However, the parties are ready to take up. If item number 17 can be taken up first, Lordship.
Both are similar, analogous.
No, both are not similar. Of course, it pertains to regularization, but item number 17, the petitioners are on contract basis, Lordship. And item number 18, they're on work church, Lordship.
What do you want?
If 17 can be taken up.
No,
first.
what do you want?
Regularization, Lordship.
Are you working still?
Yes, Lordship.
Not today.
Lordship.
If there is no urgency. You are working, no?
Yes, Lordship.
Still working.
I mean, sir.
Regularization.
Yes, Lordship.
On what basis?
Lordship, there was an office memorandum, Lordship, issued by the state of Nagaland, Lordship.
So will this override the statutory provision
Lordship.
and constitutional scheme of public employment?
Lordship.
Will it override office memorandum? What is the recruitment rule? There is no recruitment rule.
No, Lordship, there's no recruitment rule.
How you are appointed?
I was appointed on contract basis, Lordship.
So contracts, the moment contracts, contract period ends, you have no right.
Lordship, I have completed more than 10 years of service, Lordship.
About that Uma Devi, para 53.
Lordship,
Huh?
it does not necessarily, Lordship, as on today, I have completed 10 years of service, and there was an office memorandum issued by the state government, Lordship. That was a part of the judicial review, Lordship, at one point of time, Lordship.
Yes.
However, it was again appealed before a division bench, and division bench has also made some observations, Lordship. Only if the employer has completed 3 years of service, Lordship. That was the observation, Lordship.
On the basis of the office memorandum.
Yes, Lordship. On the
So
basis.
you are banking on that.
Yes, Lordship. In fact, Lordship, there are similar cases where this honorable court has also issued direction to the state government to regularize my services, Lordship. I have enclosed some similar decision of this honorable court, Lordship.
It's a covered case then.
Lordship,
If it is covered case, why unnecessarily we go for a hearing?
Maybe
You examine it.
maybe
Is it covered?
no, my lord, here,
If you say it's covered, will civil direction will may issue, but then if you want to examine that whether this is covered case or not. Those cases are the contract on what
Yes, Lordship,
capacity?
contract, Lordship.
The
In
post
Or
is a particular post.
yes, Lordship.
What post?
LDA, Lordship.
LDA.
LDA come computer assistant.
In
Lordship.
those cases or
Yes.
your cases?
Both the cases, Lordship.
The
I'm also serving as LDA, and even in the referred cases, Lordship, he was serving as LDA, Lordship.
different
Different department, Lordship, but under the state of Nagaland, Lordship.
Ah.
Or if I may be allowed to make a simple submission, respectful submission that if my representations can also be examined, because on several occasions I have written my representation before the authorities, Lordship. If it can be examined, Lordship.
Let the government examine. It is, if it is covered case, will dispose of in the same line.
my lord, here.
If you dispute that it's not covered, then we may go for
My lord, here
Detail
in the instant case, my lord, we are not disputed in the facts. For several occasions, the department, the concerned department has already forwarded to the state government to take the decision. However, there is one division judgment passed by the honorable court. Here the petitioner, they are claiming that means they are claiming under 2004 OM. So under 2000 OM, it says that those who have completed 3 years, their service will be regularized. So in that writ petition, which was disposed by the
division bench.
has already stated OM. So against that judgment, the department, government cannot take any actions. That is why we could not consider the case.
That is the problem also.
Yes,
Even
yes.
if we direct also, if the basis is state,
Lordship. Lordship,
So
it has
the basis on which you are claiming.
Yes.
If it is decision of the matter or by the division bench or state by division bench, with the question of for direction.
For that only.
Same thing, even if direction is given for consideration of representation, they'll have the same plea
Lordship.
that this OM has been stated by division bench.
Yes.
Therefore, they are handicapped. Otherwise, also they don't want to do.
That is the
But
main
once the government has the handle, it is more tougher.
Lordship, the Honorable Apex Court Division Bench has held that only if I have completed only 3 years of service, Lordship.
But he
That's
said
the
that has
OM.
been state. That has been state, according to him.
Lordship, the OM which I'm relying on, Lordship, it has not been interfered by the
More, let us do one thing.
Lordship.
Both of you properly examine it.
Lordship.
I was thinking that if he agreed that
Lordship.
if it's covered, we'll dispose of on the same line. But he said the basis which you are claiming, the OM has been state. So you'll examine that also.
Lordship.
That will be the proper course of action. Both of you examine and be fair to the court, whether against each other or favor each other.
Lordship, otherwise I have gone through suitability test, Lordship. I have qualified. And the department has no issue. In fact, they have recommended my name for regularization, Lordship.
Then wait for that.
So, my lord, this is the only reason stopping
See.
stopping to consider the petitioner case.
So the best course of action would be
Lordship.
to pursue the division bench matter, get it disposed of.
Lordship, in fact, it's already disposed.
Already disposed of.
It's disposed, Lordship.
But then you said this been stayed.
No, my lord, that under OM 2004 and 2008 and 2016, they're claiming under that. And that these two OM has already stayed by the judgment. Passed in WPC number one.
It has been disposed of.
Yes,
Yes,
Lordship.
my lord.
It
Your
has
lordship may kindly see in the writ petition. Your lordship,
Would say,
writ petition,
17 has already been mentioned.
Yes,
The
Lordship.
file has been taken.
Yes, Lordship.
yes.
So what?
It appears that it was mentioned in the morning, Lordship,
Ah.
wrongly mentioned by one of our colleagues. Lordship.
Is it?
Yes, my lord.
We don't know consent.
Your lordship may kindly see the page number 39.
No, I don't have the file. That has been mentioned and taken away.
Lordship, in that case, it can be fixed on 18
18 were
after
fixed,
vacation, Lordship.
were
After
fixed so many matters on 18. After 25.
Lordship, if it's convenient for this honorable court on 25th or 27th, Lordship.
27.
27.
That which you are relying,
Yes,
the judgment of the division bench is
Yes.
annexed
yes, my lord. In the.
at him, writ petition.
Yes, my lord.
Lordship.
Much
Obliged, Lordship.
obliged.
What is this?
Lordship, this is also for regularization, Lordship.
Same thing.
Lordship,
727 then,
Lordship,
same
my
day.
case is slightly different from the earlier case, Lordship. I'm covered by the OM, Lordship, and it's still in operation, Lordship. There was an office memorandum issued in the year 2004 for regularization of workchurch employees, Lordship.
Then when is 27 is which date? Which day? It's Monday. 27th?
27 is a Thursday, Lordship.
Then Tuesday. Tuesday, 25.
25th, Lordship.
25. List this better. Okay. More?
No problem.
As agreed to by the learned council for the both the parties list this matter on 25/7/2023 for hearing.
Lordship. Much obliged, Lordship.
Court two over, committee section.